with the consent of the associated director mention item number 29 of the supplementary list, Lordship. In this matter, Lordship, we are supposed to file our affidavit in reply, Lordship. It is ready, Lordship. May kindly grant 10 days time to file our affidavit.
Item 29, the request made by the council.
My lord, can be on 23rd, my lord.
No,
I'm correspondent for 7.
23rd,
June 23rd. Monday, my lord.
we have not 20.
Lordship, 20 has some personal difficulty.
We can't help it. Then it goes after. That 2 days are not meant for these matters. Be reasonable when you're making a prayer.
Lordship, 19 also, Lordship.
So 19 is the hearing. So
Or 18, Lordship.
already
Lordship, interim order is here, Lordship.
interim order passed. Don't make unreasonable requests.
My lord, in 18 we have some problem with 23rd.
Matter be listed in the month of August, first week.
May please, the Lordship. I beg to mention item number 10, my lord. It is up after, my lord, 2 weeks.
So suppose there's no. Yes.
Regarding item number 10, my lord.
Item number 10, my lord.
Yes.
My lord, letter may become after 2 weeks, my lord. I am for the respondent and he is for the petitioner, my lord.
Item 10,
Yes, my lord.
July. Matter be listed after the AOP.
Yes, must, my lord.
May I please, with regard to item number 12 and 13, my lord.
Request made by. Yes.
With regard to item number 12 and 13, my lord, in this case, I have to file affidavit in reply, my lord. I need some 3 weeks time, my lord, to file this.
And for the respondent, when you we want
3 weeks.
Yes, sir. After
Item
vacation.
12 and 13 be listed again after the AOP. Request made by the council. Rejected by the council.
Obliged.
May I please, Lord? I beg to make.
can I have a date, my lord?
After July, some date will be given by the.
After filing, my lord, we shall pray.
It comes
After-
from a law.
After filing of the
You
affidavit,
want to file what?
Reply to our affidavit.
Reply. So
Yes.
After
the
filing,
moment
you
you receive a reply, you make a mention if the matter is.
Yes,
not
sir.
there. Fix a date.
obliged.
Instead of fixing a date today and again getting it returned. It is a fixed matter.
Obliged.
Fixed today.
It is fixed today, but we are adjourning it.
Because they want to file a
You
reply.
agree to it.
My lord?
You have given your consent to the adjournment.
He
Obliged.
needs to file a reply, my lord. That is why. Only prayer is for a date, my lord. My lord,
The date. 30 July.
Obliged.
May I please, Lord? I beg to mention item number 16, Lord. 16, Lord. We have consulted the other side, Lord. This is the metal, add-on,
You are for the petition.
yes, Lord. After a week, Lord. Add-on for after a week.
Item 16 of the request made by the council.
Take it up.
July. Okay. You have a mention.
Please, your lordship. Your lordship. Taken the consent from the other side. As the conducting senior counsel, Mr. S.P. Roy, won't be able to attend the court today due to personal difficulties. Matter
23. Instead, the next hearing weeks. That is adjournment. Right.
Lordship, we have filed our affidavit yesterday only, Lord.
Respondents submit that the affidavit. Accordingly, matter be listed again. You want to file a reply?
Yes, fine. In the meantime,
Listed again after the opening court. Maybe the file the reply because the time. Registry we don't result the affidavit stated to have been filed by the respondent and it is the case report. next day.
Public.
Lordship, kindly pass over for the time being. Our AT is on legs, Lord.
We'll take it at the end of admission.
End of admission. Lordship, I shall convey.
This matter relates to promotion of the petitioner method. She has been deprived from time to time, and ultimately she has to approach the honorable court, and on the direction of the honorable court, her representation was disposed of arbitrarily, rejecting her prayer. Against that, I have filed this petition,
Where is the order of prison?
my lord.
Rejection of the
That is on 29, 12, 16, and
page number?
page 47. May I read my?
Yes.
With reference to the Honorable High Court order on the subject session, I have the honor to state a few lines to draw your kind attention and necessary action. That's sorry, madam. Next page, 47. Page 47 and 15. Speaking on, whereas Srimati Monica Das was appointed as LDA on compassionate ground on 24/10/1997 and posted under the control of Joint Director of Health Services, Golaghat, at the district level office, by his director letter number so and so. But he joined in this directorate as per this directorate order against Golaghat district and was allowed to draw her monthly pay and allowances in the directorate by order number so and so. And thereafter she had prayed to the then secretary to the government of Assam to modify the earlier appointment order and to appoint her in the office of the Director of Health Services, Assam. And subsequently, the Deputy Secretary to the Government of Assam, Personnel B Department, had issued a letter to the Director of Health Services, Assam, by letter number so and so, with an instruction that the Chief Secretary desires to, for modification of her appointment, she may be appointed in a vacant post of LDA in the office of the Director of Health Services, Assam, immediately. She was attached to this directorate by order at so and so, and thereafter she was transferred to the Regional Drug Testing Laboratory, Kanapura, Guwahati, in the same capacity and the same pay scale. Whereas in the meantime,
So your name was found to be down below in the gradation
ma'am.
rates.
that is my case, my lord. That was the professional,
So what does the rule say?
my lord. My lord, if he rendered 4 years of service, he is entitled to be promoted.
No, they are not denying that. They have indicated in your order that you have the qualification.
So he is qualified, that is admitted position, but
Yes.
her position is below at 45.
Right.
That is the pain of objection. But my prayer is that that provisional gradation list was not finalized till 2020, after the retirement of the petitioner. And in their affidavit, they have stated that that provisional list was not considered in my case. But it order itself, it shows that it has been considered. Contradictory and has been taken.
What is the, where is the seniority list today? At the time you retired, it is the provisional list.
Yes, ma'am. It was not finalized, it was finalized only in 2020.
And
And her case was considered by considering the provisional gradation list.
so
where-
in the draft gradation page, had you been in service?
Yes.
You retired before finalization of the gradation.
Yes.
Now, had you been in service, what would have been your in the final gradation?
Final gradation list, I could have been placed at position number 1, because one of my junior was promoted when I was in service. In their affidavit, they have stated that that provisional list was not considered. That is in their
You are seeking promotion to the post of
senior.
senior assistant.
Yes. One junior assistant whose name is Mr. Kumar, who had joined after this petitioner, he was promoted on 13 to 20 to 2014, Annexure 24. Reply. Yes, paragraph 20 of their petition might affidavit. They have stated that that provisional list was not considered. And from the order itself, it shows that it was considered. Paragraph 20 of their affidavit.
In which paragraph they stated it was not considered?
Paragraph 20, page 75. Page 75, paragraph 20. That as regards to statements made in paragraph number 730, deponent may state that in pursuance of the Honorable High Court order dated 2/7/2008, but it was considered in 2016 matter. First in writ appeal number so appointment of appointees were revoked, and accordingly the provisional gradation list was not considered.
What was the order direction in the writ appeal?
No, in my case, matter.
No,
No, that case was filed by some other person.
so what was the direction?
Illegal appointments were there. Some persons were named in a provisional list whose appointments were
Set aside.
set aside. So
Therefore, their
accordingly,
positions were redesignated.
yes. So it was not considered. That's it. But in the impugned order, it shows that that provisional gradation is considered in rejecting my case. And secondly, one junior, Mr. Kumar, who had joined in 16/11/2005, that is Annexure 23, he was promoted on 2014. But the petition was denied.
No, but the provisional gradation is from that basis was the promotion granted to other persons.
No, my lord. That was not finalized at the time of my service, my lord. It was finalized only in the 2020.
So how your claim survives to now? What basis are you taking a claim?
My lord, my case only
Was there any order of the court that the provisional list should be finalized within a specific period of time?
no, in my case, the direction was given to the authority to consider my case. And
Where is that order of the court?
Annexure 13, page 42. And relevant portion is at page 44. Last paragraph. The facts above have been noticed as well as gotten find
Page number.
page 44.
So let us go to the facts properly. What is there from page 43 onward.
By order dated 24/10/1997, the petitioner was appointed as Lower Division Assistant under the administrative control of the Joint Director of Health Services, Golaghat. In course of her employment, she had served in the office of the Director of Health Services, Assam, and was also transferred to the office of the Government Analyst, State Drug Testing Laboratory, Guwahati. As and when the State Drug Testing Laboratory was converted to Regional Drug Testing Laboratory under the Government of India, the petitioner expressed her willingness to go back to her parent department. The inaction of the director to take back the petitioner as Lower Division Assistant constrained her to institute WBC number so and so. During the pendency of the writ petition and in view of its interim order passed by the court on so and so, the government of Assam in the office of the Director of Health Service issued the order dated so and so, transferring and posting the petitioner in the same capacity against the vacant post of Lower Division Assistant in the office of the Additional Director of Health Services, Assam. This order was followed by another order dated so and so issued from the Director of Health Services, Assam, by further transferring and posting the petitioner under the establishment of the Director of Health Services, Assam, Hengrabari. Petitioner submits that on and from 24/10/1997, she has been serving as a Lower Division Assistant under the Director of Health Services, and in terms of Rule 9 of the Assam Director of Establishment Ministerial Service Rule 1973, she is legitimately entitled to promotion as Upper Division Assistant. A fringe issue has been raised in the affidavit in opposition filed on behalf of the respondent number 3 that the petitioner had remained absent unauthorizedly while under the service of the Regional Drug Testing Laboratory for the period from 1/10/2002 to 28/2/2004. This issue does not gain significance in view of the fact that the period of absence has been regularized by the order dated so and so, issued from the office of the Director of Health Services. Another issue raised in the affidavit in opposition is with regard to the fact that the petitioner was included in a gradation list by giving effect from 1/7/2010, that is the date of her joining in the cadre of Lower Division Assistant at the Director of Level Post. The date of her joining as appearing from the gradation list not being under challenge. This said issue is not gone into. Even going by the date of her joining,
Where is even financial upgradation?
my lord,
Were you considered for financial upgradation?
yes, one.
One.
Yes.
After how many years? 10 years.
After 10 years, I am entitled to second
And,
upgrade.
how many years did you put in after at the time of
About 18 years.
above 18 years? So the financial upgradation was given in lieu of promotion.
First upgrade.
First upgradation you got in which post? You LDA.
Yes.
Lower division.
Yes.
Junior assistant.
Yes.
So after 20 years you would have got your second upgrade.
Yes.
Yes.
Yes, because I have not completed 20 years, so I am entitled to get promotion. Because I have annexed one affidavit. One of the employee was employed similarly with the petitioner. He has got the first upgradation, financial upgradation, and secondly, within 14 years, he has got promotion. So there is
She has got promotion from which post?
from LDA to
In the
Yes.
same department.
same department.
On the basis of the same gradation list.
Yes.
Where is that order?
Annexed Annexure 27,
Page number.
Annexure 22, my lord.
Page number.
Page 113. Subject. Page 113.
Yes.
Subject to reversion without notice and without assigning any reason thereof, funding recommendation of the selection committee following senior assistant of the director of health service Assam.
No,
Sorry,
this is senior assistant.
27.
This is senior assistant.
Yes, my lord. Annexure 27, page 129. I am very sorry. Annexure 27, page 129. Last page.
Yes.
The pay in respect of Sri Madhusmita Day, junior assistant of the directorate, who was promoted to the post of senior assistant high director. That means he was promoted. That Madhusmita Day. He was promoted in the year 2019, my lord. In gradation list, at page 39, my lord.
And you are assailing which order? Page number? Impugned order?
My lord, 47, page number 47.
Petition to speak, no. Good document.
Okay, Mr. Gogoi.
And the case, my lord, is, my lord, based on this particular document, my lord, that is at page number, Lordship may kindly turn to page 36. Though the petitioner was initially appointed as compassionate on compassionate ground as LDA in the Joint Director of Health Services Golaghat, she was transferred, officially transferred and posted under the Directorate of Health Services by this order, 9/6/2010. That's why, my lord, her seniority, my lord, as LDA in the Directorate was considered from this particular date. She has been referring to the initial appointment of 1997, my lord. That is not permissible, my lord. Directorate, they have got a separate cadre. Well. She joined here
No.
on.
That is not her ground. Her ground is that the draft seniority list on the basis of which she claimed a promotion was not considered by the authority. They have, if you come to page number 47 or
No, 47 is the speaking order.
48 is the speaking order,
Yes.
but her name in the gradation list is that serial number 45.
At page 39, Melo.
Huh?
Page 39.
39.
Lordship will see, my lord, serial number 45, page 39. Her initial date of joining, my lord, has been considered as 1/7/2010.
But this, she says, is a draft gradation.
So even if it is draft, my lord, whether, my lord, she can be considered from 1997, that is the issue, my lord, to be considered. She wants that her seniority should be counted from 1997. So Lordship may kindly have a look at page number 21 for a moment, my lord, from the initial appointment that has not been placed. Page 21 for a moment, my lord. Just few documents I will place on page 21. This is the order of appointment on compassionate ground. Lordship will see subject to satisfactory police verification report. Monica Das, lead petitioner, wife of so and so, is appointed provisionally and temporarily on compassionate ground as LDA. So and so as admissible under the rules and posted against a vacant post at Golaghat under the administrative central of Joint Director Health Services, Golaghat, Assam. This is our initial appointment in the district cadre. Now, Lordship will see in page 23. 23 says, when it is a letter from the Deputy Secretary, Personnel B Department to the Health Department, Director of Health Services. It says, I am directed to invite a reference to your order cited above by which Srimati so-and-so was appointed as LDA in the office of the Joint Director of Health Golaghat. The Chief Secretary desires, Lordship will kindly mark this one, that her appointment letter may be not modified, says modified, and she may be appointed in a vacant post of LDA in her office immediately. The matter may kindly be treated more urgent, copy of so-and-so. So, as per, my lord, desire of the, my lord, Chief Secretary, her initial, my lord, appointment was, it was, my lord, modified to the extent that she will be working, Lordship will see page 25, in the statistical branch of the Directorate of Health Services on attachment. Lordship will see, my lord, the last second line of the first para, page 25. In attachment until further orders and placed in the statistics branch of this director. On attachment, he is still holding the post in Golaghat.
My lord, it says
And again, let me complete.
Page number 36.
Now, 25. 25 is the order of attachment after, my lord, the appointment. Lordship will see, my lord, the last second line of the first para. In attachment until further orders and placed in the statistics branch of this director, pursuant to the request made by the Chief Secretary. Well, for completion appointment, there will have to be a post. He was appointed in Golaghat, under the Joint Director of Golaghat, on the request of the Chief Secretary. On attachments, he have been kept here.
If she is in Golaghat,
Yes.
then what rule will govern her?
Then it will be a district, my lord, establishment rule, not by the director. Even then, my lord, Lordship will see in the subsequent, I will place, my lord. Place 28, Lordship will see, in 1999, Lordship will see this order, second para. Transferred so and so on relief. Srimati Monica Das, LDA cum typist, Office of the Drug Inspector, Golaghat. She is still in Golaghat, my lord, as per our record. Though she is working on attachment. Who is working in this directorate on attachment? In the interest of public service, transferred and posted at the office of the government analyst, state drugs testing laboratory, so and so, transferred. So again on attachment, she was placed in the state drugs testing laboratory in 1999. Thereafter, page 30, Lordship will see. This is the letter dated 4th of July 2002. It says, my lord, a prayer petition along with other connected papers, I am directed to say that the personnel department directed to appoint Srimati Monica Das as LDA in the office of the Director of Health Services Assam as desired by the Chief Secretary, Assam on compassionate ground. It appears that she was posted at Joint DSS Golaghat and attached to the office of the Director of Health Services Assam. Subsequently, she was transferred to the drugs testing laboratory Khanapara, the above facts are in violation of government order issued from the personnel department as well as the order of the chief secretary. In view of the above, you are requested to see that Srimati Das is transferred to the office of the DSS as directed by the personnel department in the letter under reference above. The letter I have placed in page 23. They have referred to that, where the chief secretary has desired that she should be placed in the directorate by modifying the earlier order. Now, page.
No, but then why these things are not available in the order? The order by which her case was rejected
Lordship.
merely says that your name is found in the gradation list as 45.
No, it is clear, my lord, from
Where-
2000,
where
and I'm,
is-
my
where
lord, that's why I'm saying, my lord,
where
let
is
me
the
place the
gradation?
other document.
Where is the gradation list?
Before that, lord, she will see, my lord, page 36. Finally, she was transferred, officially transferred, not on attachment. She was transferred and posted in the office of the Director of Health Service.
This is by which order?
Page 36, 9/6/2010. That's why this particular date has been counted, my lord, while considering her seniority, my lord, in the directorate cadre. And going by this particular, my lord, date, she is, my lord, she is junior to, my lord, the private respondent, my lord. If she can show a single, my lord, individual who have been promoted, who has joined in the directorate after, my lord, 9/6/2010, of course, he will have a case. Which she has failed, my lord. She is considering her, my lord, initial appointment, that is in 997, while considering the, my lord, seniority, which is not, my lord, permissible as per the law. And in fact, my lord, in that particular year 2010, there were certain persons who have been newly appointed. They joined, my lord, just prior to the petitioner joining in the directorate as per the transfer order. We have stated in affidavit. In fact, they are private respondents here. Pursuant to a direct selection, my lord, recruitment process, they were appointed. And they joined prior to the petition. So that's why their names are above her. Though, my lord, they have appointed in 2010, being the direct
How many
recruitment.
vacancies were there?
My lord, the speaking order says there is no vacancy available otherwise also. Even though she is, my lord, junior, no vacancy was available. And in fact, my lord, there is a judgment of the Honorable Supreme Court, very recent judgment, which says, my lord, person here who has retired, who has never worked in a particular promotional post, he cannot claim, my lord, a promotion on a retrospective effect and give, my lord, and to pray for, my lord, notional benefit in fact, my lord. There is a, my lord, judgment passed by the Honorable Supreme Court in 2024.
That is the concept of proportional.
Yes, even that is not permissible. Because in that particular case, her name was recommended by the promotional committee meeting. But during the process, my lord, when it went to the government, before issuing the promotional order, she retired. So she approached the Honorable Court. The Honorable Supreme Court said that no, it's not possible. Since you have not worked in that particular post, even on notional basis, it will not be, my lord, possible. Since he was not born in that particular cadre. Para 15. Para 15, my lord. This is the issue that was framed. Para 16 is the issue record there. 21 is the final order. Lordship will see page 39 for a moment, my lord.
We have seen that, but I think this is with regard to the rules, because there are other
No,
judgments which are not considered yet. Other precedent of what is a notional promotion. If this is the law laid down for notional promotion, then there can be no claim for notional promotion.
No, even then, my lord, she will have to establish that from 1997 her case is to be considered. If that is established, my lord, of course he has a case. That's
This
what I'm saying, my lord.
judgment perhaps is rendered on this rule 54(1), para 70.
Regarding that, my lord,
The findings of the
officiating capacity.
yes. Perhaps in rule 54(1)(a), some claim must have been made that he was allowed to officiate and he is not getting. So that context, perhaps the apex court held that he did not even hold the post for 1 day. So there is no scope for claiming that.
No, my lord. The Honorable Supreme Court has said, considering that respondent was superannuated before his promotion was effectuated.
That's right.
There is a promotional
No, no,
committee's
that's right.
recommendation.
But with then perhaps with reference to rule 54(1)(a).
Yes, that was considered. That was relied upon and that was considered. But the
It
fact
is not
remains
a-
that
it is
even
not
if
a general proposition that for all future purposes no claim for notice. This is perhaps with reference to rule 54(1)(a). Some claim must have been made
yes, claim was made, of course. That was
under
taken.
54(1)(a). So
But Honorable Supreme Court said that since he has not joined in that particular post.
right, not joined in view of rule 54(1)(a). Otherwise, there is no occasion to refer to rule 54(1)(a). 54(1)(a) is pay on officiating appointment.
My lord.
So it is possible that he was officiating in that post and thereafter his
Yes.
promotion was given effect to, then he is now claiming notional benefit on the ground that he was officiating, whether he is entitled, not entitled to the different issue. Here is a case where he did not officiate, even for 1 day.
Yes. As a my lord, regular scientist or something. Yes. chief scientist of scientific officer. My lordship will see page 39.
But even while saying so, there is a reference to page at para 19.
Lordship. Yes.
Para 19 of the what page numbers are there?
19, there, my lord, the Bihar state related to the board.
Then thereafter you'll find Ajit Singh, but the state of
Ajit Singh, yes.
this is the Constitution bench judgment says that there is the right of being considered for promotion.
No, that is a fundamental right.
No, so therefore, if you are otherwise eligible and you have not been considered for promotion,
Yes.
violate your fundamental right.
So that eligibility part, that's why I'm saying if we can establish, my lord, that from 1997 her
So
seniority
if
is to
it
be.
violates your fundamental right, then what happens if the person retires? Will there be no claim for full benefit?
In fact, my lord, so far as the consideration part is concerned, Article 14, my lord, that has been already considered, it has been rejected and speaking order.
If this is the proposition to hold,
Not.
that there
Yes,
will be
yes, of
no
course,
claim
that
for
one, yes, consideration will be required, and if it is rejected, he has a right to challenge it. There is no,
definitely.
yes,
So,
yes.
which you say that this is the proposition for that no further,
The-
no notional promotion,
and the
that
door,
is-
door is closed.
have to be held to be overruled.
Lord,
It has not been done.
Lord, Lord. Well, my lord,
So
coming to the facts of the case, my lord,
Yes.
Lordship will see page 39, my lord. Just one heading I will show, my lord. Just I want to point out. Page 39. Provisional gradation list of LDA in this directorate. So she joined in 2010, June 2010. That's why in serial number 45, date of joining has been shown as 1/7/2010, which is not disputed, and not 1997. This is the gradation list of the directorate, not of the entire state of LDA or the state junior assistant. So she was born in this particular cadre in the directorate on 1/7/2010. All along, she was on attachment under a directorate, under the state drug testing laboratory in Khanapara and statistical branch of the directorate and all, my lord. Not, my lord, regularly posted hearing. That's why, my lord, whoever was there at that point of time, already working under the directorate on regular basis, pursuant to, my lord, their direct recruitment process, whether they can be deprived of their promotion. That's because somebody from outside comes and, my lord, joins in the direct. That is the whole
your case,
settle law, my lord.
this draft list is considered.
But in rejecting my case, that draft provisional list was considered. That is true, my lord. My submission is that they have wrongly considered because my position should not have been placed at 45. Because I have joined it in 1997, and those there are several communications from the directorate as well as the government from the Undersecretary Government of Assam. They have said that the earlier order issued to the petitioner placing her at district level was completely illegal.
But then you'll have to array the persons who are likely to be affected in case the gradation list is
No,
directed.
my lord, at least at this stage, my lord, I want only national benefit.
No.
Because no,
Your notional, for you to establish your notional benefit, you must say that you did fill all the parameters necessary for to satisfy the qualification, satisfy the experience. But your name, the gradation list was downbeat. Therefore, firstly, there were no vacancies, they say. Assuming there are vacancies, then perhaps it is
no vacancies were there while I was in service, my lord. In that respect also, I have submitted my affidavit stating that at least 7 vacant posts were there in the year 2014.
this order was passed pursuant to an earlier order
Yes.
of the High Court.
Yes.
So, in that matter, these issues are not raised. The petition earlier petition of the director that your case be considered as a key order.
Yes.
It challenge the gradation is there.
My lord, I have not challenged that order.
In the earlier writ petition, did you challenge the gradation list?
Only promotion.
Only promotion. You did not challenge the gradation.
Yes, never.
The same gradation list is now being used,
Because it was not finalized by at that time.
but it may be.
I was expecting that it will be finalized because I have filed objection immediately within 15 days of
That prayer is not there. The prayer, the director, the architect, repetitor, it consider your case. And they have considered it. If the gradation is gradation is, then some finding has to be there in the earlier orders. Then first it has to be finalized, then the further direction for consideration. Either you come to the court, pray for a direction for consideration or promotion, which means the gradation list is accepted. If the gradation list is not accepted, then your prayer should have been this gradation list is not finalized, so that I know where I stand.
We don't have the option.
Once you get an order, once you write an order from the court, taking a direction for promotion, that means the gradation list is accepted. Gradation is accepted. Today you are saying that no, that decision is not correct. You did not finalize. This was that objection. It was raised. We are proceed. It was not done. It will amount to reopening the earlier one. You are not filing a review against that order.
My lord, I have filed this petition only because this order has been passed by saying something contradictory. Only because of that.
Sorry?
I have filed this petition because this speaking order has been passed. It was not properly considered the factual position.
What is the
And
factual position you want?
Contradictory, and they have
The finding of in the speaking order is in the second last paragraph of page 48.
yes,
Second last. Or third paragraph.
as per
Third paragraph of page 48.
her prayer could not be considered because though she has necessary qualification for the promotion and she has rendered service more than 4 years, but her name is found in the graduation list of LDA serial number 45. But at present, there is no available vacant post. My lord, that is one point, my lord. At present, there is no vacant post. In the first paragraph, last line, the same page. Accordingly, this directorate has kept one post QTA vacant in the office of the DH. They kept one vacant post, and subsequently they have said that there is no vacant. They have systematically deprived the petitioner
No,
from the
they have kept one post vacant.
Yes.
In the event you are found to be eligible, they will be promoted. Now, you are not found to be eligible because you have completed, you have the necessary qualification, you have completed 4 years. But your name is
below.
below. Even if we overlook this, even if you say that this vacant post is contradictory to the earlier statement, fact remains that your name is at 45. Unless say, now say one vacant post, it normally entails 3 or 4 persons to come. 3 times or 4 times the number of vacant will be selected.
No, regarding vacancy position, I have filed affidavit. But at that time, several vacancies were there.
Where is that? Where is that order?
Well,
Where is that affidavit?
Annexure 22,
Say the page number.
page 113.
Which paragraph?
7 persons were there.
Para 3.
Page 113, Annexure 22,
1, 3.
113.
7%.
7 persons were promoted to the post of senior assistant on 12 February 2014.
So 7 vacancies.
7 vacancies. And I
Even
have
if you
applied.
even if you apply for 7 plus 1 more vacancy, 8
Yes, ma'am.
8 into 4 is 32.
Ma'am.
What does the rule say? If you come to rule 8AA, capital AA,
I'm very sorry, my lord. I have not taken the.
you don't have the rule. Page number 173.
Eight double eight.
8 double.
Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies of the register and superintendent to be filled up by promotion in the next year in the cadre. The appointing authority shall then furnish to the selection committee the following documents and information with regard to as many incumbents in order of seniority as are eligible for promotion. Number A, information about the number of vacancies, list of incumbents in the order of seniority eligible for promotion to the rank of superintendent and register, ACR of last 5 years of eligible incumbents, details about reservation. The appointing authority shall simultaneously request the selection committee to recommend within 1 month separate list of officers found suitable for promotion in order of preference for promotion to the post of superintendent and register respectively. The selection shall be made on the basis of seniority cum merit, and after selection of the selection committee shall furnish a select list of officers in order of preference found suitable for promotion. The appointing authority shall consider the list recommended by the selection committee and finally approve the list. The select list shall remain valid for 12 calendar months from the date of approval by the appointing authority. The promotion shall be made in accordance with the list of finally approved. Senior assistant, that is 9, rule 9.
Yes.
Appointment shall be made by the appointing authority.
No,
by
this is not. This is the qualification. The 8AA does not specify how many number of
No, my lord.
number of persons will be called for, but let us assume that there are 8 vacancies.
Yes.
Even if 4 times the numbers are called for, 32 persons will be there for selection PPC.
Yes, yes.
Your number is at 45. You are out of the zone of consideration.
Yes.
Therefore, we close it at this stage.
That is up to your lordship, my lord.
No, no. It is left up to me, subject to if you have given me some material to pass an order in your favor.
My lord, exactly.
You are challenging the order on the ground that there is a contradictory view that one post was kept vacant, but they say there are no posts available.
Yes.
But this one post vacant doesn't mean it was kept vacant for you. Your case will have to be selected as per the rules. Rules say seniority come merit. Your position is at 45. There are 7 or 8 vacancies.
But in that case, my lord, may I submit one thing, my lord? One of my junior, he was appointed.
Then you have to challenge their appointment.
He has also retired.
But you have to challenge that appointment.
No, in that case,
Let us say that 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 person who was a junior was wrongly given an appointment. We can't give you an order to say that the same benefit should be given
no,
to
I
you wrongly.
do not want any action against that person. I want that as my junior was promoted prior to me, my lord, so I may be allowed the national benefit from
But
that.
in order to make that claim, you have to challenge her promotion. Why was she given promotion prior to you if she is your junior?
May I submit one judgment of our High Court?
Yes.
Criteria for promotion being seniority come merit. Petitioner found to have stood within the zone of consideration on the date of promotion of his junior, right to be considered for promotion as a fact of fundamental right. Stress. Petitioner having retired from service before approaching court, direction issued to grant national benefit of promotion.
To come to para number 4.
In the meantime, the petitioner had become eligible for consideration promotion to the next higher post of executive engineer. 2 vacancies in the post of executive engineer arose in the department, and therefore a meeting of the selection committee was held on censure for filling up those 2 posts by way of promotion. The selection committee had considered the case of the rate petitioner along with 2 other eligible candidates to ensure.
See, so somebody was arrayed as a party.
Yes.
Whose promotion they are challenging, that person's promotion should not have been given before the petitioner. It is the case, you have not even questioned that promotion. That is what you'll have to challenge that promotion to say that instead of her, you are entitled. Yes. your city council has agreed. It is not. We'll give you one more day to think about it. We'll fix it on Thursday.
Yes.
List on Thursday. Enabling both parties to address the court. Right. Please share your judgment with each other so that whatever judgment you are relying, please
Yes.
share it with it. They will also give you guidance. List on Thursday. Thursday.
Right.
Better after some time.
Right.
Roy, he's in October 17.
We'll start off with the hearing. Let him come. How long is it going to take? Mr. Roy is not here.
He's here, Your Lordship.
Let him come. We'll hear. You inform him. He'll require some time to address the court. Yes.
The issue involved is the petitioner was terminated from service after a departmental inquiry. He approached this honorable court. This honorable court set aside the entire proceedings and directions at page 24 of the writ petition is justified. Page 24, para 34. This is a judgment of 2015 where it says, thus it is evident that the procedure laid down by the apex court in the case of Kumari Madhuri Patil has not been followed in the present case, which has vitiated the decision-making process, culminating in the decision to remove the petitioner from service. Accordingly, and in the light of the discussions made above, the imputed order of penalty as affirmed by the appellate authority cannot be sustained and are hereby set aside and quashed. Petitioner is directed to be reinstated in service, but without any package.
He
This
claimed,
being done, my
claimed
lord.
to be some ST.
My lord,
SC
yes.
member.
He claimed to belong to the SC category. They said that the
Certificate is
was
not genuine.
not genuine, that he did not belong to a certain tribe. Kumari Madhuri Patil was not fraud. And thereafter, the court also observed in the writ appeal that he did not claim the post of an ST candidate. He had participated as a general category candidate. So whether the certificate existed, did not exist, that made no matter at all. He was allowed to continue in service. That writ appeal lordship will find the interim order passed in the writ appeal at page 25 on page 27, para 8. It was there writ appeal, where para 8. This honorable court in the interim held, the writ petitioner was recruited in the year 2023 against open category vacancy and not as an ST category candidate. Nothing is brought on record by the appellant to show otherwise. Hence, we declined to pass any interim orders in the appeal. When he was still not being appointed or reinstated in service despite this order, Lordship will have the last lines. In the other orders, in other words, the appellants are required to reinstate. There was another order to reinstate. They did not reinstate. During the pendency of the appeal, the Honorable High Court directed the personal appearance of the DG of the force for not complying with the orders of the interim orders in the writ appeal. At page 29, they moved an SLP, where Lordship would find at page 30. The DG was not required to appear, but some other officer, higher officer, who was stationed at Guwahati was required to appear. When that order came at page 31, this is where our
So
difficulties
that
come.
was declined.
My lord, they appeared and they reinstated me. Now, Lordship would find it page 32, where the difficulties come. The last paragraph I am reading. In view of the above, I the understand hereby set aside the punishment of removal of service imposed upon so-and-so by commandant so-and-so, and he is hereby reinstated into service with immediate effect in consonance with the order dated 25/1/17 passed by the division bench of the Honorable High Court of Guwahati in writ appeal number 22. Reinstatement of Vikas Nath is conditional subject to outcome of writ appeal. On his reinstatement, he is posted to 84 Battalion. He is also directed to report on duty to 84 Battalion within 15 days of receipt of this order. He is not entitled for break wages, that is from the date of removal of service till reinstatement, as held by the learned single bench of the Guwahati High Court, passed in so and so. This is the difficulty. The intervening period, date of removal of service till reinstatement, is treated as period not spent on duty. However, the above period is condoned for the purpose of pension under Rule 25 of the CCS pension. When the Honorable Court in first setting aside set aside the termination also, my humble submission, there could be no occasion for the Director General to have set aside the removal of service again. All he was required to do was to reinstate me. The only thing that was denied to me was the back wages. However, he goes on to hold that it would be treated as a period not spent on duty. How this affects me, my lord? This affects me because my continuity in services for all other purposes, including seniority, consideration for promotions, my tenure required for being considered for promotion, everything goes with this order. The writ appeal order, Lordship would find. Now, Lordship, the final order, once I was reinstated, comes on page 34 and 35. The same thing is repeated, that this period will be treated as period not spent on duty. At page 34 is the order by the commandant while reinstating me. Page 35, relevant portion, page para 7. The last few lines. The intervening period, date of removal of service till reinstatement, is treated as period not spent on duty. However, above period is condoned for the purpose of pension only.
You're reading from
Madam,
35.
page 35, para 7. From the bottom, the third line, last word, ND. And the intervening period, date of removal from service till reinstatement, is treated as period not spent on duty. Thereafter, the writ appeal came to be disposed of. The effective portion, Lordship will find at page 41. Para 10. When the matter is being given its final consideration in the appeal, the appellants could not produce any reasonable ground as to why this court should differ with the conclusion of the learned single judge in its judgment and order dated 10/4/50. It is noticed that the entire basis of initiating the discipline proceeding against the respondent and also in arriving at a decision to remove the respondent from the service was the opinion of the Deputy Commissioner upon verification that the respondent belonged to OBC Yoginath community and he does not belong to the Scheduled Tribe Post community. This court does not find any reason to differ with the view taken by the learned single judge that the basis of arriving at a conclusion as regards the correctness of the caste certificate produced by the respondent could have been verified only by the High Power Committee constituted pursuant to the direction of the Honorable Supreme Court in Kamari Madhuri Patil case, and the basis of such conclusion could not have been a verification report by the concerned Deputy Commissioner. It is further being noticed that it was the specific stand of the respondent that he was appointed as a general category candidate by satisfying its qualification requirement, and he was not appointed on the basis of such caste certificate. No material has been produced by the appellant to controvert such stand of the respondent. When I was being denied, or I have been denied my pay fixation, I have been denied everything by the respondent, and I made an application at page 43.
No, what?
At page 43, I made an application where at page 44, the last paragraph, since then I have been drawing my basic pay 23,800, whereas my batchmates have been drawing basic pay of 35,300. My basic pay is much lower than the first person who is my immediate junior.
Why was the basic pay lower now?
My lord, what they had done is when they treat it as period not spent on duty, what I was earning on the date of my pay scale at the date on which I was terminated has been taken to be my starting pay on my reinstatement. Therefore, my lord, I have lost not only all that continuity in service, I remain a junior to my erstwhile juniors because that period is taken off from my service.
Can you recover?
For the recovery will not be there because I was already terminated. I was terminated on a particular date. That order was set aside by this honorable court, and I was supposed to be reinstated in service. What they have done is this period not spent on duty becomes honorable court did not give me the packages. So now they are starting where I had left. taking away my this entire service except for the purposes of pension, that is, it will be counted only as a continuing service from a pension period. Now, I lose out my pay fixation, my increments, my chances of promotion, and in certain cases where I need a certain length of service to be considered for any post, that period also goes. That, my lord, in my humble submission, is not
You are challenging this.
only that period not spent on duty part.
Where is that order?
That order located in conduct page. It starts at page 31, the order of the Director General,
Relevant
when
part
they were
of
required.
para 6.
My lord,
Para 6.
para 6, the last portion. The intervening period, that is date of removal from service till reinstatement, is treated as period not spent on. Now, I do not want what would be reasonable in law for them to have done is, since this honorable court had already rejected the back wages, it will be taken to be continuing in service with all notional benefits. They cannot take away my service period, keeping it only for the purpose of pension. My seniority has to be restored. My pay has to be fixed as if I was in service throughout that period with my increments and any other benefits that I was entitled to, save and except actual pay.
What do the respondents?
My lord, the respondents in their affidavit in opposition have not given any justification for the same, save and except at page 8 of the affidavit in opposition, para 16. They refer to the orders which I have just referred, the DG's order, saying that since the DG says he is not, that period is to be not spent on duty, we keep it as not. Effect of a reinstatement and how the period, Lordship, in my humble submission from what has flown from the orders of this honorable court are twofold. One, that the procedure was not followed, there was a procedural flaw in terminating my service. And secondly, on the very merit that I had never contested or appointed as an SC category candidate. In both the counts on merit and on the procedural part, the termination was set aside. They did not go for a fresh inquiry proceeding. They did not do anything further, they simply reinstated me. If that be the position, Lordships may refer to the case of Dipali Kundu Survasya, in which the Supreme Court has said how the period has to be Lordship has para 32 for what? Lordship would have para 32 on the second last page. No, the page number printouts of not. Para 32. Well, this judgment had, my lord, basically dealt with the back wages part. The continuity in service was dealt with at para 32 and then at para 33. Para 32, my lord, I have meeting.
Yeah.
We may now deal with the judgment of JK Synthetics Limited versus KP Agarwal and another Supra in detail. The facts of that case was that the respondent was dismissed from service on the basis of an inquiry conducted by the competent authority. The Labour Court held that the inquiry was not fair and proper and permitted the parties to adduce evidence on the charges level against the respondent. After considering the evidence, the Labour Court gave benefit of doubt to the respondent and substituted the punishment of dismissal from service with that of stoppage of increment for 2 years. On an application by the respondent, the Labour Court held that the respondent was entitled to reinstatement with full pay wages for the period of unemployment. The learned single judge dismissed the writ petition and the division bench declined to interfere by observing that the employer willfully violated the order of the Labour Court. On an application being made by the respondent under Section 66 of the UP Industrial Disputes Act, the Labour Court amended the award. This court upheld the power of the Labour Court to amend the award but did not prove the award of full back wages. After noticing several precedents to which reference has been made herein above, the two-judge bench observed. There is also a misconception that whenever reinstatement is directed, continuity of service and consequential benefits should follow. As a matter of course, the disastrous effect of granting several promotions as a consequential benefit to a person who has not worked for 10-15 years or who does not have the benefit of necessary experience for discharging the higher duties and functions of promotional post is seldom visualized while granting consequential benefits automatically. Whenever courts or tribunal direct reinstatement, they should apply their judicial mind of facts and circumstances to decide whether continuity of service and consequential benefits should also be directed. Now, Lordship should have para 33 to 33. On the last page, Lordship will have Roman clause 7. The observations made in JK Synthetics Limited versus KP Agrawal that on reinstatement, the employee workman cannot claim continuity of service as of right is contrary to the ratio of the judgments of the three judges bench referred to herein above and cannot be treated as good law. This part of the judgment is also against the very concept of reinstatement of an employee or a workman. Then Lordships may like to have paragraph 16 on the third page.
This is the
So JK Synthetics, when it held that there will be no continuity in service, so it cannot be claimed as a matter of right. What I'm trying to emphasize is this judgment says JK Synthetics is wrong to that extent. It becomes a matter of right. My continuity in service is a matter of my right. Once I'm reinstated.
impliedly overruled.
My lord. JK Synthetics was accepted. Now, Lordship would have paragraph 16 of the judgment on the third page. On the third leaf.
Rule.
Paragraph 16, Lordship has?
Rule. Para 16 of
1-6.
reinstatement.
The word reinstatement has not been defined in the Act and the rules. As per Shorter Oxford English Dictionary, the word reinstate means to reinstall or re-establish a person or thing in a place, station, condition, to restore to its proper or original state, to reinstate afresh, and the word reinstatement means that the action of reinstating re-establishment. As per Law Lection, 2nd edition, the word reinstate means to reinstall, re-establish, to place again in a former state, condition or office, or to restore state or position from which the object or person had been removed, and the word reinstatement means establishing the former condition, position, or authority. Reinstatement of a deposed prince. As per so-and-so, the word reinstate means to place again, to restore a previous effective state. As per Black's Law Dictionary, reinstatement means to reinstall, re-establish, place again in a former state, or condition, or office, to restore to state or position from which the object or person had been removed. The very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been, but for the illegal action of the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. With the passing of an order which has the effect of severing the employer-employee relationship, the latter source of incomes get dried up. Not only the concerned employee, but the entire family suffers great adversities. They are deprived of a source of sustenance. Children are deprived of nutritious food and all opportunities for education and advancement in life. At times, the family has to borrow from the relatives or other acquaintances to avoid starvation. These sufferings continue till the competent adjudicatory forum decides on the legality of the action taken by the employer. The reinstatement of such an employee, which is preceded by a finding of the competent judicial, quasi-judicial body or court, that the action taken by the employee is ultra vires the relevant statutory provision or principles of natural justice, entitles the employee to claim full back wages. If the employer wants to deny back wages, the employee and contest his entitlement to get consequential benefits. Contest his entitlement to get consequential benefits, then it is for him or her to specifically plead and prove that during the intervening period, the employee was gainfully employed. One was getting some emoluments. Denial of back wages to an employee will suffer due to illegal or employee amount to indirectly punishing the concerned
So this is
employee and rewarding the
back
employee.
wages.
My back wages was already denied to me, but the other part, the reinstatement part, as if I was never terminated, is what has to follow. One of the consequences would be back wages. I was denied that. I did not challenge them. But my notional fixation of my seniority, my pay, my continuity in service cannot be denied in the manner it has been done. Even the fundamental rules which refer to a period of a diason, of a period which it is diasional, even in that case, at least a notice is required to be given for judgments of this honorable court. Here, while following the orders of the honorable court, when facing adverse situation in the writ appeal, they hurriedly reinstate me, taking away my entire period of service, which was held to be illegal by this honorable court, both on merit and on procedural infirmities.
Yeah.
So that part of the order, if removed,
You're assailing only that part.
only that part, that it cannot be deemed to be period not spent of
Yes,
duty.
Mr. Teka,
Chief,
where you are arguing counsel.
affidavit is filed, but in absence of Mr. Roy, I have no authority.
So like it,
Lordship, after some time, Lordship, after 10 minutes.
Mr. Mosultar, after some.
May it please your lordship. Lordship, in the last order, we were directed to produce the records, but we did not receive the records as of yet.
How much
Lordship,
time do you
it can
require?
be fixed after a week or a two.
I'll let it be go after vacation. Mr. S. Dotto, counsel for the respondent, what for submit the record for him. Breathe for further time. Yes. Yes. We can ask the case. And therefore, then paper to be listed in the month of July on a date to be fixed by the registrar.
Much of
Please, your lordship.
It be your lordship, kindly possible for timing lordship. Adhar is in another court.
Who?
Adhar.
Yes, what is your matter?
My lord, non-payment of pensionary benefits, my lord. And the husband of the petitioner died, my lord, before regulation of his service, my lord. And similar circumstances, coordinate bench of this honorable court passed the, my lord, order or whereby granted family pension.
Your husband was a master role,
Master worker,
not regularized.
subsequently regularized, my lord, after death,
After death,
my lord.
where is that order?
My lord,
It's 30.
Lord, page 30, my lord, coordinate that order. And in that case, my lord, the husband of the petitioner, my lord, retired before regularization, my lord, and subsequently died, my lord. relying some citations regarding
My lord, this
Yes.
case will not be covered by Sanchita Roy. There is a little difference. My friend has annexed that order of Sanchita Roy. Why, my lord? My lord, here is a case. The petitioner was regularized in 2005. My lord, the thing is that his name was there in the regularization list, but he died prior to, my lord, the regularization. In 2004, he has expired, my lord. He was not in service when that regularization came in, my lord. His name was sent, my lord. Prior to that 1 year, he expired, my lord. That is the problem.
Regularization is with effect from which day?
22/7/2005, my lord.
And he expired on
Expired on my lord 2/12/2004,
1 year before.
my lord.
So, based on, my lord, Sanchita Roy will not come in, my lord. Sanchita Roy is about, my lord, that 6-year gap period, my lord. That earlier it was rejected. The Honorable Court has, my lord, set aside that 6-year gap, my lord. Here it's little different.
Ordinate bench, my lord, page 30, my lord. The husband of the petitioner also, my lord, died, my lord, prior to regularization.
What do you say about the judgment at page 30?
Page 30. 30.
My lord, here is a case whose service book was prepared, my lord. Service book was there in place. Here there is no service book. My lord will come to page 30, para 3. The case of the petitioner here is that a husband on such and such was appointed as muscle worker in 1884, and in the office of the PWD Lanka, section such and such, a service book was prepared in 25/8/1994, and after rendering 20 years of service, her husband retired from service on such and such date after attaining the age of 58. It is further, so my lord, he has retired. He was not in service, and before regularization, in current case, my lord, he was in service and he, my lord, expired before the regularization, order was passed. Here is a case, my lord, where service book was in place. The department has created, my lord. I don't know, my lord, but here the agriculture department has categorical that no He was a temporary worker, and that is why no service book, my lord, was prepared, my lord. He was in a role. In para 8, we stated in the affidavit, my lord, page number 44, that with regard to the statement made in paragraph 6 of the petition, it is mandated that
So in the case referred, he was a master role worker. This case
Master role. Same.
with a service book.
with the service book.
No, my lord.
No,
It is the submission of the petition, my lord. Kindly see paragraph number 5, my lord. Page 31. Page 31, my lord. In pursuant of the said notice, the respondent number has filed a affidavit in opposition on 3/2022. In the said affidavit opposition, it has been
No service
Men-
book was prepared.
mentioned that the husband of the was appointed so and not as worker. It is mentioned that no service book was prepared against Emma Rebart as per government rules, and only master role was maintained. In that regard, the identity card was issued by the division on 25/8/1994 to the husband of the petitioner, and same cannot be said to be a service book. Well, here also no service book was prepared. It is further mentioned that the husband of the petitioner joined on division on MR labor on 1/10/1984 and retired from service on 31/8/2004. And subsequently, my lord, he was regularized with effect
my
in
lord will
22/7.
take one thing in consideration, my lord. For a pension, my lord, he has to be regularized. And he has to be service. Here, that thing is not there, man. My lord, I think we'll have to, even I'll have to look for some other laws, my lord. Because this is a very interesting case, my lord. He was not, he expired before that, my lord. So,
What was the ultimate direction here?
My lord, direction, my lord, kindly see, my lord. Page 39, paragraph 18.
itu mulu ka tuti aisa legal opinion.
As direction, my lord, to condone the, my lord, deficiency of 1 year, my lord, under Rule 67. And subsequently, my lord,
There is no mandamus, my lord. This is with regard to, my lord, there is a deficiency of 1 month.
the claim is better footing, my lord, than that this judgment. The husband was serving more than 20 years, my lord, 23 years. Here, my lord, serving 19 years. That's why, my lord, Rule 67, my lord, directed, my lord, to
But
condone,
ultimately, there was no direction to condone the delay.
my lord.
Deficient.
Well.
Para 18, serial number 3. It was only directed to consider.
My lord. Shall take appropriate steps to release the pension subsequently, my lord. If the deficiency, my lord, in service is condoned. But regarding condonation of qualifying service is not, my lord, in my case, my lord. My lord.
Here the
More
petitioner
than
died.
20 years, my lord, service. And my lord, in
You
effect,
have been regularized
regular.
subsequently.
Subsequently, my lord.
After his death.
Means, my lord, the list was being prepared from 2003. The process was going on. His name with the along with other 2000s, my lord, went there. It got regularized, but in the meantime, he expired, my lord.
Why the benefit was not granted?
My lord.
Why the benefit was not granted?
My lord, since he expired, my lord, and then how could he, my lord, gone forward with, my lord, giving pension, my lord. He has to be in service, my lord.
What is your stand in the affidavit?
10, my lord. Only the paragraph number 10, my lord. Page 45. Decision is at higher authority.
What is the meaning of that?
Affidavit opposition by the
This is by the director. Higher authority means, my lord, government, man. Because it has to be taken by the government, my lord. If government did not take a call, my lord. My lord, basic thing we have to draw it from para 8. In para 8, my lord, we have to correlate with para 10. It is mandatory that the government servant should have completed minimum 1 year of service. The service book of the deceased husband, the petitioner was not maintained, SQ has not was working as MR worker and expired before regularization. So after regularization, minimum 1 year he has to, my lord, be in service, my lord.
Who has placed this judgment here?
My lord. Yes, my lord. This apex to judgment where, my lord, the granted
Subsequently,
family
there are
pension, my lord, for ad hoc employment.
Prem Singh.
My lord, Prem Singh and Tulsi Bhai Thanji Bhai, my lord.
Prem?
And subsequent judgment, my lord, regarding delay and losses, my lord. Continuous cause of action, my lord, but it cannot. Yes, because, my lord, I have filed, my lord, affidavit of
You share with him the judgment. Let him address the court.
my lord.
Thursday. Please don't.
Yeah.
Thursday. Enabling the state. Respond. PWD.
Serial.
For the state.
My lord, serial certificate.
Serial.
All right.
Yes.
In the last occasion, we are happy to file the affidavit, but due to some difficulties, we could not file it. So finally, we get time for we file the affidavit.
You are representing who?
Private respondent 4 to 14 and 16 to 21.
It is become too late. All earlier dates, they're taking care.
You file it within 2 weeks. Beyond that, we are not granting you any time. Mr. P. Chaudhary, Mr. Your name?
MK Bora.
MK
On behalf
Bora.
of DJ Bora.
For respondent number
4 to 14, 16 to 21.
4 to 14 and 16 to 21. It submits that the affidavit on behalf of the respondent on type the JK Goswami and JK Governor is for respondent number
1 to 3.
1. It is made clear that no further time is granted for filing the affidavit. If the respondent wants to complete the pleading, they may do so within the next 2 weeks.
Let me
Is started today on 2020.
okay.
Yes.
But
This is a matter where the petitioners, there are 300 odd petitioners, my lord. They have been working in the foreigners tribunals of the state on contractual basis as, my lord, data entry operators, copyists, peons and chowkidars. And they were, although appointed contractually or temporarily, they were selected for appointment pursuant to a regular advertisement issued by the High Court and selection process initiated and undertaken by the High Court. I'll refer to the pages, my lord. By the High Court, they were appointed. Now there are 100 tribunals. 36 were created way back in 1985, and there are in 2014, additionally 64 numbers were foreigners tribunal, as your lordship know, were created, my lord, totaling about 100 foreigners tribunals. In between, my lord, in 2019, some 200 additional tribunals were created, but were closed in 2022. It will be very long if I go and refer to every, my lord, environment. So now there exist 1,000 tribunals, and all these 300 persons have been working on fixed pay as data entry operators. They are, my lord, skilled. Even a driver is skilled. Copyist and peon. Now the present salary, and we are not in the additional 200 which were created in and then abolished, my lord. We were prior thereto. The data entry operators were given, my lord, 10,000 rupees per month over last 9-10 years. And copyists, peon, chowkidars were given 9,000 rupees per month. Now, my lord, our grievance is that the duties we are discharging are of perennial nature, but they have been denied any due remuneration. We claim that in the same advertisement, other posts in FTs, though contractual in nature, have been given regular pay scale, but data entry operators and copies peons were not, my lord, which were lordship will find, though we, my lord, discharge the same duties like the regular incumbent serving in as duty data entry operator and all, that your lordship will find a page advertisement. Have a look at the advertisement at page 71, 72.
So you are still working, functioning.
Yeah, we are working.
Your
As on today, we were working.
enhancement of pay, which has been rejected. So
We are working, discharging same duties. My lord, this is the way we were, my lord, our posts were advertised. Lordship, page 71. This was by the High Court, my lord. It was of 2015. Lordship may come to page 72. Next page 72, your lordship will find the eligibility and selection criteria for post of UDA cum accountant, and a pay scale is given. Pay scale is given. And they were also, my lord, filled up on deputation basis. Then for eligibility and selection for LD assistant, bench assistant, and typist, we are copyist, my lord. Here again, my lord, the word pay scale is there. Then come to the next page, 6. Eligibility selection criteria for data entry operator, that is me, we, in the same process they were allotted, my lord. It is fixed. The word is fixed, 10,000 per month. Fixed. Higher secondary pass, fixed. Then eligibility for copies, it is 9,000 per month, fixed. Then eligibility selection criteria for office peon, it is 6,000 per month, giving 9,000. So this is how we were lastly at the rate action of the authorities, and all were appointed, my lord, in February 2019. I have referred to pages, my lord. The appointment letters.
Is the standing council, is the registry of the High Court not a necessary party?
My lord, we had no grievance against the High Court. We have given against our appointing authority is not High Court. Our appointing authority is state government, and they say fund comes from.
But the
Right.
advertisement was issued by the court here.
It's all right.
Where are your appointment orders?
78, 79. We have nothing against High Court. High Court was entrusted or maybe requested. Good. 78. This is the type of appointment order, my lord, at page 71. It is given by Government of Assam Political Department in pursuance of High Court's notification dated so and so. Ministry of Home, Government of India's letter dated following 200 candidates merit list are engaged data entry operators in foreigners tribunal. 10,000 rupees per month, fixed. Engagement will be contractual and purely temporary. No dispute about that. It is contractual and temporary, my lord. And page 90. Oh, yeah, page 90. This is for copyist. Page 90. This is also of February 2019. Similar order. Candidates merit list are engaged as copyists. Foreigners Tribunal Assam in fixed pay of 9,000. Then 94, that is also February. These are for peon, and their fixed salary is 9,000. So copies, data operators, office peon, all 9,000. And 101, Chokidar. They are fixed at 9,000. So this is how, my lord, we were appointed, and never thereafter it was enhanced. And my lord, the impugn order, it is all because of the impugn order at page 140. Our appointing authority is government. 108.
140.
108 is basically, my lord, 7 pay commission. It has been converted to, my lord, the Assam Service Revision of Pay Rules 2017, department-wide.
Where is the order of rejection?
108.
108.
The orders I have shown, my lord, all February, beyond to the data entry operator, 9,000, 10,000. Then, my lord, the pay revision at page 108. Here, Lordship may come to page 111. 111.
Here.
It is categorized as junior industrial service grade. Last entry below, extreme below, data entry operator, a pay band is given. Pay band is given. Same nature of duties, they function. A regular pay band is given. Then 113, Lordship will find, even for copyist, a pay band is given. And the pay structure is given. Then group D service, beyond Chokidars, these are, here also the pay band is given. And they draw about, my lord, 35,000 now, as on date. And the same duties we perform. Now, my lord, the impugn order is at page 28/8/2003. This is the hurdle. Why they are not? 2000, page 203. 140 is what? 140 is Yes. No. It is order dated, my lord, August 28, 2023. This is by, my lord, Government of India, Ministry of Home. Lord, may go to paragraph 3 straight away. Since Government of Assam had proposed creation of this supporting staff on contract basis, they have been engaged on contractual basis against temporary posts created for additional temporary 64 FTs, and their services are purely temporary in nature and not governed by rules and regulations applicable to regular government servants. It is not feasible to grant regular pay scale to this temporary supporting staff engaged on contractual basis. So this is basically the order we have impugned, and it came before
Are there
different
any
bench also
set of
earlier.
governing your service? Are there any set of rules governing your service?
No, no.
No service.
We are contractual. We are contractual
On
discharging.
contract.
But there are decisions, including, my lord, this court and Supreme Court.
I'm trying to understand the factual metrics of your
No, no rules.
No.
No.
You are on contract.
On-
This period of contract is extended periodically.
There is, and we are discharging the same duty. Equal pay, equal work. That is the task of the principle that will come. And several branches of this honorable court, and then Supreme Court, my lord, dealt with it in the existing matter. I'll come later. I am just highlighting my predicament and our predicament is where we have been trending. So appointment is also contractual for LD and UDS, right? For them also there is no rule. I've shown their appointment, no rules for them. Same advertising, same manner of appointment. But somehow the UDs and LDs were given a pay scale, right? And we have not been given.
UTs and LDs in the foreigner tribunal.
Yes.
They're getting the regular pay scale.
I have found my PV band 2, PV band 3. The PV band was given to them.
No, it's PB band that you're referring to. Is it only for FT or that's the general scale of pay?
FT.
It's only for FT.
FT. Now reply, my lord, the posts are temporarily created. Now, FTs are not, I submit, my lord, these FTs cannot, since 85 it is running, my lord, some additional were created and then discontinued. They are likely to continue. Detection of foreigners is an ongoing process, my lord. Therefore, indefinitely, almost we are serving in the FTs for indefinite period. Already served for 88 long years. Then, my lord, scale of pay to be denied who are integral part of the institution, and it has been observed by this court and relied on judgment of Judge Singh. I will come to that, my lord. There is a appointment of the petitioner, though contractual. The tribunals are, my lord, likely to continue. It is a perennial process in view of this detection process is going on. Detention centers are saying it is not a fact that posts which the petitioners have been appointed are for a limited purpose, just for fixed pay only or outsourcing staff. They use the word outsourcing. Government of India, na?
Today early morning, I have mentioned one item number 23, your lordship, which your lordship has passed an order that it needs to be listed in the next hearing list. But your lordship, there is an urgency that your lordship, all the employees have got their VRS amount, but only the petitioner is. But your lordship, it's an urgent, your lordship. Kindly, your lordship, matter may be taken. Item number 23, your lordship. Your lordship, after vacation. No, your lordship has passed an order that it needs to be listed in the next hearing list. But your lordship, earlier also we have filed one IA that it was in the hearing list. Lordship, a date. And my argument, my lord, I have a small prayer, my lord. Today, uh, today is the day of my mother-in-law date anniversary, my lord. I have to, my lord, it will be, my lord. I can say, no, not that time. Yes, ma'am. Yes, my lord. I thought, my lord, but my lord, I can hear. Yes, ma'am. Yes,
I have,
yes.
I have completed my, I have think my junior has prepared a gist of my submissions also that I can give you.
Let's take me. Okay.
Let's take you. Yes, ma'am.
Perfect.
Perfect. Awesome.
Perfect. Did it? Did
Yep,
it?
yep.
Yes.
Some accommodation, my lord. Some accommodation I not gone and for that therefore 17.6, my lord. That may be fixed, my lord. My lord. Obliged. Okay.
May I please, your lordship? The matter has come for my lord admission, and some observation was made, my lord, for final disposal. The matter released to my lord
regularization of the service of the petitioner, who have been working, my lord, for last about, my lord, 29, 30 years. Now, earlier, my lord, there are two writ petitions moved before this novel court, and matters went up to, my lord, division bench. Division bench observed that since there was a decision taken by the responding authorities, you act upon the decision. Then there was, my lord, nothing happened. Then we had to come once again before this court. And this time also, my lord, court observed that, of course, my lord, court has taken note of the Umadevi's case. But court at the same time, court observed that since there was a decision, therefore that decision, on the basis of that decision, my lord, appropriate step may be taken. Now they have filed the affidavit, my lord. In their affidavit, my lord, if I can understand properly, they took different stand. They are saying that we are appointed, my lord, against temporary post. There was no selection as such. Sometimes they are saying, my lord, there is a ban. Therefore, in view of the ban, they are not in a position to regularize this service. And sometimes they are saying that there was a ratio in between, my lord, non-technical and technical. And non yes, non ratio in between. In between. In between academic and non-academic, unless and until that ratio is achieved, my lord, they are hardly in a position to take any decision. Now, I am in a position to substantiate, my lord, my argument and to negate their stand by referring to my particular document, particular annexure. It appears from that annexure, my lord, exhibit Q&R, that they themselves, my lord, observed that we were appointed against permanent post, sanctioned post, and there was some sort of selection. By the annexure A and B, my lord, A, B, C, that clearly shows that we are sponsored, my lord, on being requisitioned by the NIT. Earlier it was REC, Future Engineering College. And our names were sponsored. There was some selection. They issued call letter. We are selected. We are appointed. And report also shows, my lord, we were appointed against sanction post. Lordship may have a look, my lord. At page 117. Regularization. And I understand, my lord, regulation is not a, my lord, well-recognized mode of recruitment. But at the same time, regulation is not unknown to law. Even in Umadevi's, more than some persons are more than 30 years. And some are about to complete 30 years. Stand of the respondent is many folds. Sometimes they are saying there is a ban. Sometimes they are saying we have taken a decision in terms of the order of the court, that since there is no, my lord, earlier order of the court. Yes, yes. It was passed by Honorable Justice Sanjay Medhi. Initial order is, my lord, Lordship, kindly turn at page 86. That was the original order. Page 86. Judgment. And that order was, my lord, ultimately we approached division bench. Division bench also observed that since there is a decision, you take a decision. You have adopted resolution. Then nothing happened. By that time, my lord, on 21/9/2013, 27/9/2013, by annexure M, they, my lord, adopted, my lord, fresh decision. by adopting a resolution, they took a decision to regularize our service at page 102. My lord, annexure M at page 102. Yes, my lord. Yes. 103. That was the resolution. 103, resolution 3. It is also resolved that existing MR, so and daily workers working in neat shelter since last several years are to be regularized. It is their own decision. From amongst the MR and daily wage workers on phase manner, on phase wise, subject to availability of the post. Therefore, so far as the availability of the post is concerned, there is no any dispute as such, because by that time, they have issued advertisement. We have also challenged that advertisement. This is under challenge in this writ petition. Then, they didn't do anything. Then we filed the present writ petition. Now they have come with the affidavit saying that now they are going to resort to Rule 19, 2019. They said there is no any provision in the rules itself. Rule Act page, my lord. $166. That is the rule which commenced, my lord, which came into force in 2019, and decision was in 2013. Can, by referring to, my lord, provision, negate their own decision? And my lordship knows, my lord, no recruitment rule, my lord, can have any provision regarding regulation. Regulation is something, my lord, which was altogether, my lord, not appreciated by the Supreme Court and this honorable court. Therefore, there is no any question to have any provision in the recruitment rule. And one more thing, my lord, I have, to my limited knowledge, I couldn't understand. At page 168, they have given some, my lord, criteria. Next page, 168. Lordship may have on the top of that particular schedule, my lord. Technician. We are holding technician, semi-technician and skilled technician. Not applicable. What is the meaning of that, man? I don't know. Whether selection test, selection post or non-selection post, not applicable. They passed the impugn order on 5/9/2024, and in that particular, my lord, impugn order, they specifically took a decision that there is no any question to regularize the service because there is no any provision in the recruitment rules. And at the same time, they took a decision that our status is nothing but a temporary. We never appointed against in sanction post. There was no any selection whatsoever. But this is not the correct factual situation. And that will be evident from page 118. May I take your lordship note at page 118? we are, my lord, 67 in association. And exactly the same figure, my lord, is reflected at page 118. I'm just reading, my lord, if your lordship permits me, my lord. 118. And at the same time, my lord, central government also issued a notification whereby they are saying that the person who, my lord, engaged prior to cut-off date, as that of, my lord, the state government, on 1/9/1993, they are otherwise eligible to be regularized. And that notification of perhaps, my lord, by exercising power under Article 162. (134). Yes, my lord. Para 16. Taking into consideration the aforesaid facts and circumstances, the court directs the Ministry of Human Resource and Development to immediately issue a communication indicating the guidelines to be adopted while considering the case of the petitioner in terms of the order dated 5/12/2012. Page 96. That was the order passed by division bench. Then, my lord, they did not act upon this. Then ultimately we were compelled to come, my lord, court once again. And, my lord, hence this petition. In terms of, yes, guideline is there, my lord. At page, my lord, 135. Annexure U. At page 135. And 135. Ultimately, division bench, my lord, there is no basic change. Division bench also observe that you take a decision. And there is a specific, my lord, regulation or anything. There are no provision in the recruitment rules. Or my lord, my lord, my lord. My lord, any date, my lord, after 16th July. My lord, my lord, they are proposing to, my lord, fill up the post, my lord.
Already filled up.
My lord. And since, my lord, selection is under challenge, Lordship may be kind enough to make an observation that this is subject to result of the case. Whatever, if they are already made an appointment, my lord. My lord. Our case is simply our simple case is, my lord, whether we are entitled to be regularized. My lord.
Wait. Well, there is a cancer society in Assam. They appointed the petitioner. Now, the petition has been, sorry, my engagement has been terminated based on some allegation. That is the case. Now, if the lordship would kindly take the writ petition, page number 28. The petitioner was the appointment order. We are pleased to appoint you as consultant radiologist, Dibrugarh Cancer Center on contract with Assam Cancer Care Foundation for a period of 1 year from 1st August 2002 till 31st of July 2023 on the following conditions. Well, these are the terms and conditions. If you lordship to kindly come to page 29, there's a termination clause. ACCF shall be entitled to terminate this contract at any time, giving
13 days notice or by paying 1 month's fee in lieu thereof. You shall be entitled to seek termination of the contract after giving 30 days notice or by paying 1 month's fee in lieu of notice. In case ACCF terminates this contract for any misconduct found on your part during the contractual period, termination shall be with immediate effect and you shall not be entitled to any compensation. Now, my lord, page 30, there is an arbitration clause. In the event of any dispute or difference arising between you and ACCF, it shall be referred to arbitration. And my lord, now Supreme Court says that arbitration clause by itself is nothing. In spite of that, judicial review is permissible. Now, at page number 38, my lord, the contract was extended. Yes. But then, my lord, I have got all those decisions where Supreme Court has said it will not take away your lordship. At the end of the day, my lord, it's a power of judicial reviews and basic structure of the Constitution. How can an arbitration clause take away? There are specific judgments on this point. Exactly. Now, my lord, what had happened? Here in this case, based on some misconduct, allegation of misconduct, my service has been terminated. Therefore, it, my lord, assumes the character of punishment. Once there is a punishment, my lord, rules of natural justice has to be followed. Yes, yes, yes. If a lordship should kindly, in fact, they have taken a stand in the affidavit. If a lordship should kindly take the reply affidavit, my lord. Page 117. Page 117, part of the reply. Assam as a lot. Assam Cancer Care Foundation is a joint partnership between Government of Assam and Tata Trust. It was set up in December 2017 to create a first of its kind 3-level cancer grid in the state. The distributed care model was conceptualized by Trust and the Government of Assam to create patient-centric cancer institutions to deliver standardized and affordable care closer to the patient's home. The foundation is expected to benefit 50% of the Assam cancer patients. And if you lordship to kindly come to 119, my lord, and we see who all are the persons involved. Himanta Biswa Sharma, Chief Minister, Kekhab Mohanto, Honorable Minister, Health, Vijay Singh, Vice Chairman, Tata Trust, Siddharth Singh, IS, Commissioner and Secretary, Siddharth Sharma, CEO, Tata Trust, so and so direct. So government nominees are there, my lord. Then my lord will kindly come to page number 126. Now, one of the director is the Chief Minister of the state, my lord. Is the audit report 126. Towards the bottom in the middle of the page, in the middle portion, director. Then my lord will kindly come to page 149. It shows, my lord, the funding pattern. 1,910 crore corpus for cancer care in the state. Then if your lordship kindly comes to the next page, as a part of opening funding, Tata Trust will contribute 830 crore, while state government will provide a grant of 1080 crore. Health Minister Himanta Biswa Sarma told media persons here. So, my lord, there are deep and pervasive control of the state of Assam. Lordship knows the attributes when an authority would assume the character of authority under Article 12. There must be, whether there is any funding by the government, whether there is any people in the management from the government. So, my lord, the two basic criteria as propounded by the Supreme Court in Azaya and in subsequent cases are present. So, prima facie, my lord, subject to what the other side say, my lord, here is a case where I don't think on the point of Article 12 any problem should be there. It is subject to what they say, I reserve my right of reply. Now, coming to the merits of the case, my lord, I have already placed my appointment order. If your lordship would kindly come to page 38, that is the extension of the contract. In reference to your letter dated 4th of May 22, your contract with Assam Cancer Care Foundation has been extended from 1st of August 23 to 31st of July 24. Professional fee for your contract period from 1st of August 23 to 31st of July will stand revised at so and so. 50 lakhs 88,000 and odd per annum. Then, my lord, on 18/7/24, a mail was sent by the petitioner to the authority. Now, yes. My lord, let me place two very important judgments, my lord, that will clarify the issue, my lord. First of all, 2011, 15 SCC 16. Yes. My lord, this is a judgment which stresses the history as to why the judicial review in such matters is available. Though essentially it is a matter covered by a contract, and it can also be construed as a case of a contractual violation. Please come to para 38. A conspectus of the pronouncement of this court, and it page para 38 at page 29. Yes. After referring to all the case laws. Now I'm placing 2011 15 SCC 16. Oh. Sorry, madam. Wrong. Yes. 2011 15 SCC 16 para 38 at page 29. A conspectus of the pronouncements of this court and the development of law over the past few decades thus show that there has been a noticeable shift from the stated legal position settled in earlier decision. The termination of a contractual employment in accordance with the terms of the contract was permissible, and employee could claim no protection against such termination even when one of the contracting parties happened to be the state. Remedy for breach of a contractual condition was also by way of civil action for damages and compensation. With the development of law relating to judicial review of the administrative action, a writ court can now examine the validity of a termination order passed by the public authority. It is no longer open to the authority passing the order to argue that actions being in the realm of contract, it is not open to judicial review. A writ court is entitled to judicially review the action and determine whether there was any illegality, perversity, unreasonableness, unfairness, or irrationality that would visit the action, no matter the action is in the realm of contract. Having said that, we must add that the judicial review cannot extend to court acting as in judgment over the decision. Court cannot sit in armchair of the administrator to decide whether more reasonable decision or course of action could have been taken in the circumstances. So long as the action taken by the authority is not shown to be vitiated by infirmities referred to above, and so long as the action is not demonstratively in outrageous defiance of logic, the writ court would do well to respect the decision under challenge. In other words, my lord, to the three recognized grounds of judicial review: illegality, irrationality, and procedural impropriety. On these three grounds, my dear, judicial review will be available. It's not that merely because judicial review is available, therefore writ court will see it as a appellate court and substitute its view. No, a decision-making process. Then, my lord, the second point. Second point is arbitration. Next decision, my lord. 2021 6 SCC 15. No, these are two interconnected, my lord. It is in the realm of contract. Arbitration is a remedy which is normally, yeah. Yes. Yes. 2021 6 SCC page 15. Please come to para 65 at page 51. Now the arbitration clause is quoted in para 65. I will not trouble your lordship with the clause. Then please skip over to the next page, para 66 onwards. It's a case, my lord, where there was no ground taken. Even then, what Supreme Court says, that is very important. Even though there is an arbitration clause, the petitioner herein has not opposed the writ petition on the ground of existence of an arbitration clause. There is no whisper of any arbitration agreement in the counter affidavit filed by so-and-so to the writ petition in the High Court. In any case, existence of an arbitration clause does not debar the court from entertaining a writ petition. It is well settled that availability of an alternative remedy does not prohibit the High Court from entertaining a writ petition in an appropriate case. The High Court may entertain a writ petition notwithstanding the availability of an alternative remedy, particularly where the writ petition seeks enforcement of a fundamental right, where there is failure of principles of natural justice. Here in this case it is there. Where the impugn orders or proceedings are wholly without jurisdiction, the virus of an act is under challenge, reference may be made to Whirlpool, etc., etc. In Harbanslal Sahania versus Indian Oil Corporation, this court allowed the appeal from the order of the High Court, dismissing a writ petition and setting aside the impugned judgment of the High Court, as also the impugned order of Indian Oil Corporation, terminating the dealership of the appellant, notwithstanding the fact the dealership agreement contained an arbitration clause. It is now well settled by plethora of decisions of this court that relief under Article 226 of the Constitution of India may be granted in a case arising out of contract. However, the jurisdiction under 226 being a discretionary, High Court may usually refrain from entertaining a writ petition which involves adjudication of disputed questions of fact and which may require analysis of evidence of witness, etc., etc. So, my lord, only this situation, High Court would refrain. Otherwise, my lord, the existence of an arbitration clause is no bar. The Tankia construction is there, ABL Limited is there, so many other cases. So, therefore, I was trying to harp upon the merits of the case. Short matter, just 2-3 pages, I will conclude. Now, if your lordship kindly comes to, have seen my extension order, then on 18/7/24 at page number 39, I wrote to the authority regarding my ensuing extension. Please note terms and conditions of somewhere in the middle of my contract renewal, which is due by the end of this month. Type 1, full-time consultant intervention of radiologists, revised pay scale of 6.5 lakhs per month. Please note change in the title of the post. Type 2, part-time consultant radiologist, including 4 hours only for calls and consultation and reporting. Extra charge for doing any intervention. Revised pay scale of 3.5 lakhs. Please also allocate special bonus incentive for doing invasive procedure for free out of goodwill for the last 2 years at the same time at the time of contract renewal. Please apprise me 1 month in advance if non-renewal of the contract is sought. My last working day is July 34th, open to negotiation. Now, what had happened, I was primarily appointed as an consultant radiologist. Initially, I was appointed as consultant intervention radiologist. However, I'm sorry, my lord. He was engaged as a consultant radiologist, but she was also asked to do the work of consultant intervention radiologist. Now, my lord, after I wrote this letter, they replied to me, which your lordship will find at page 42. On 9th of September 24. On 26th of July 24, we had a detailed discussion with you on renewal of your engagement contract with ACCF. This is based on request put up by you for a review of your professional fee by email dated 18th of July 24. During the discussion, we had clearly mentioned that as per the company policy, 6% increase on your current professional fee can only be considered, and you had agreed to it. But it has now been brought to our notice that you have requested for profit sharing for a few procedures. Since the practice of profit sharing is not available to the full-time consultant of ACCF, management has decided to exit the engage with you and not renew the same. You are eligible for 30 days notice payment so-and-so of your contract. In case of notice payoff, the same shall be processed along with your final statement with the company. So, my lord, actually what had happened, there are few events which I must point out, my lord. On 26/7/24, which we have stated in para 7 of the petition, an online meeting was held with respondent number 3, where respondent number 3 assured the petitioner regarding renewal along with an increment of 6%. Apart from the issue of renewal, my lord, discussion also took place with regard to scope of the work of the petitioner, as he was asked to perform consultant intervention radiologist work over and above her work as a consultant radiologist. As such, my lord, she expressed her willingness to accept the extra remuneration for doing the job of intervention consult. So, on 26/7/24, the discussion took place on this line. Now, based on the paragraph 8, we have stated, based on the assurance given by respondent number 3. Petitioner contended to continue to work in the month of August 24 as consultant radiologist and performing invasive procedure. In fact, P was given the salary for the month of August, but without that 6% increase. So actually my contract ended in 31st of July. Following discussion on 26/7/24, I was allowed to work for the month of August, and I was paid also, but I was not paid that extra 6% which they promised. Then, my lord, if your lordship to kindly come to para 9 and 10, this is very important. This is what transpired. At page number 10, Miller of the writ petition. That the petitioner states that on one hand, the respondent number 3 failed to renew her contract, and on the other hand, they never gave her an increment of 6% as stated, but expected her to perform duties beyond the scope of her work. In fact, the petitioner was overburdened with work referred from other centers also, and even was asked to train visiting doctors in certain procedures and perform OT duties. As such, finding no other alternative as the respondent themselves failed to deliver on their promises and commitment about the renewal of the contract period, petitioner wrote an email on 23/8/24 requesting respondent number 3 to pay extra remuneration for the work done beyond the scope of her work. It is pertinent to mention that even though the petitioner contract was not renewed, but she never refused any patient, and only issue was that she was overburdened with work and it was beyond petitioner's capacity to attend every patient as forwarded by the authority. The petitioner states that thereafter on 9/9/24, the petitioner was informed about an online meeting scheduled around 4 p.m., which was intimated to the petitioner about half an hour ago without any prior intimation. In the said meeting, respondent number 3 failed to answer any query put up by the petitioner as to why respondent number 3, even after assurance, was not issuing the extension of the contract letter as promised. Petitioner again reiterated her stand that she never asked for any profit, rather she only requested remuneration for the extra works which she was being made to do beyond the scope of her work as per the terms of the appointment letter. Thereafter, the meeting ended without any conclusion, and respondent number 3 promised to look into the matter. However, same day, my lord, immediately at around 4:30 p.m. after the meeting, to the utter shock and surprise of the petitioner was handed down a letter dated 9/9/24, whereby it was stated that management has decided to exit the engagement contract with the petitioner and not renew the same. The irony is that in the aforesaid letter, respondent number 3 themselves accepted that offer given by respondent number 3 was of 6% increase on petitioner's current professional fee for renewal of the contract, which was accepted by the petitioner, but the contract was terminated on the ground that petitioner requested for profit sharing for a few procedures. Now, if your lordship to kindly come to the impugned termination order, my lord, that is at page number 44. It is out and out stigmatic. 42 is the type copy, my lord. On 26th of July 24, we had a detailed discussion with you. 42 million, I'm sorry. That's the type copy of the order, impugned order. Yes. On 26th of July 24, we had a detailed discussion with you on renewal of your engagement contract with ACCF. That is based on the request put up by you for review of your professional fee by email dated 18th of July 24. During discussion, we had clearly mentioned that as per company's policy, increase on your current professional fee can only be considered, and you had agreed to it. This is very important, Miller. I agreed to it. But now it has been brought to our notice that you had requested for profit sharing for a new Q procedure. Since practice of profit sharing is not available to the full-time consultant of ACCF, management has decided to exit the engagement contract with you and not to renew the same. Well, as if I was trying to get a part of the share of the profit. That's why they have not given. So if this is not stigmatized, what else is, my lord? When they themselves say that I agreed on 6% increase. So therefore, my lord, an element of allegation is involved. Lordship knows when an element of allegation is involved, as held by the Supreme Court right from Purushottam Lal Dhingra till date, my lord, you cannot just get rid of me like this. You have to provide me an opportunity. There has to be an inquiry where you must bring out an allegation that this is the reason you wanted share in the profit, that they must have established it. Then only they can take this impugn action. So, my lord, our simple case is, it's a clear-cut case where I was made to work over and above my regular duty as an consultant radiologist. I was doing some invasive procedures for which I demanded some increment, which they agreed. And thereafter, my lord, on the plea that I was demanding, how can I demand share of profit? And secondly, my lord, yes. No, my lord, but it has now been brought to our notice that you have requested for profit sharing for few procedures. That is their case, my lord. Yes, my lord. No, my lord, kindly see the context. I'm oblivious of it, my lord. However, to my utter shock and dismay, the decision to unanimously terminate my contract letter, citing reason for profit sharing, which is always subject to negotiation and discussion, is not valid at all. Here I would like to add that I had demanded procedural cuts based on the previous verbal promises made by Kasturi Kolita during my initial appointment 2 years back, wherein she mentioned that in due course of time, we could enter into profit sharing mode also. Following the turn of events when company denied me my procedural cut, I have continued to do imaging guide procedure without any extra remuneration even in the month of August 24. I informed that I am willing to accept 6% increment as discussed in the previous meeting and not enter into profit sharing mode. Still you assert to terminate my contract. Because earlier, kindly see the context, my lord. They have not taken note of the fact that Kasturi Kolita made that offer. The context is different. And secondly, my lord, they know I was pregnant at that relevant point of time. And they knew. And my lord, I have been deprived of my dues under the Central Act, that 1961 Act, Social Security of 2020, Section 62(6), 68(1) proviso. My lord, the matter in my humble submission is, my lord, you have taken note of some alleged misconduct or allegation. But the moment you take note of it, had it been a simple case that there is no enough work in the organization, we cannot retain you any further, or we can visualize a situation, my lord. Supposing I was a provision. Now my period of provision was coming to an end. Then my appointing authority makes an assessment of my performance. And in that process, my appointing authority notices some shortcomings in my performance, or maybe there are some allegations against me. At that stage, if they say I'm not suitable for the job, it's a pure and simple case of termination simplicity, without any stigma. But here, my lord, you are alleging that I am demanding profit, therefore we cannot retain you. This is not correct, my lord. That is why judicial review. There is arbitrariness, there is irrationality, and there is violation of principles of natural justice. So this is my case actually, my lord. Unless, my lord, secondly, my lord, my maternity benefits has not been given. I would say, my lord, in fact, I have made a statement. When I disclosed the fact that I am pregnant, then they thought for few months she would be not there, therefore might as well get rid of her. So this is also one of the reasons why they have got rid of me. No, that situation did not come. I would have. My lord, I'll just place one judgment. I think on Article 12, if your lordship wants, I can place that Pradeep Biswas's case. I don't think it's required. Then on, my lord, other point also it is not required. Then, my lord, the matter boils down to that simple point, my lord, whether with a stigmatic order I could have been discharged like this without following the principles of nature. At the end of the day, you are casting a stigma on me. It's not a case that I demand. I agreed to do what 6% extra work. So this order is arbitrary, my lord. It cannot withstand judicial scrutiny. End of the day, my lord, nowadays, with the change of the policy of the government, the nature of appointments have also changed, my lord. Earlier, yes. If the termination order is interfered with, the consequences will follow. Yes. No. Yes, that is what we have done, my lord. We say, yes, principles of natural justice. Yes, that is our case. Yes. No, that is not the case, my lord. My case is that it's a clear case where principles of natural justice has been violated. Yes. So, lordship should kindly come to para 17, my lord, page 21. That the petitioner states and submits that she was terminated from the employment unilaterally based on the allegation that petitioner demanded profit for her extra working and leaving her with the stigma for the rest of her life. Therefore, respondent number 3 terminated the petitioner arbitrarily and adjudged her guilty without even conducting an inquiry, which ought to have been akin to Article 1011 of the Constitution of India, and thereby following the due process of law. Thus, the petitioner has been meted out with hostile discrimination and unfair treatment. He has the constitutionally recognized norms of administrative fair. So this is our case, my lord. And 18 also, petitioner states and submits that issuance of the termination order dated 9/9/24 and thereby dismissing her with the allegation of profit sharing without holding any inquiry and following the due process of law has violated her rights guaranteed under Article and 16 of the Constitution. So it's a case where we are trying to project, my lord, that the manner in which the decision has been taken is not correct. In other words, the decision-making process vitiates because the prescribed procedure has not been followed. Now, I may not be strictly, or rather, Article 10 and 11 2 directly may not be applicable because I am not a government servant. But then principles of natural justice has to be applied, my lord, as has been said by the Supreme Court in so many cases. In fact, in Gridco's case, those were the arguments, that essentially it's a case covered by a contract. Where is the scope of judicial review? The Supreme Court says those stated positions have undergone a radical change. Now kindly see, my lord, even government is appointing person with fixed pay. 20 years back, could it have been conceived? Now the concept of tutor has come, for example, in Assam government. Equivalent, the teachers who get a regular salary scale of pay, tutor get a fixed pay. That's why our High Court has said that you reconsider this decision. Well, the time has changed. Because of the change of policy, so many changes have come. Therefore, my lord, law has to adapt to the changing requirement. It was up to July, but I was allowed to work for the month of August. Up to August 24, I worked. And salary was also paid minus that 6% increase. But thereafter, on the 9/9, there was a Milot online meeting. Suddenly at 4:30, instead of communicating the decision, they said, sorry, you are terminated. After the online meeting at 4:30, I was communicating. And during the online meeting also, my lord, they came to know about my pregnancy. That we have highlighted. But these are some of the reasons, my lord, why we feel that the action is bad. Subject to what my learned friends say, my lord, I reserve my right of reply.
May I please, your lordship? My lord, in our affidavit in opposition, the articles of association is at page 70. Where at page 71, it has been specifically stated that the company is a private limited company within the meaning of section 268, the Companies Act of 2013. The company is limited by guarantee, and accordingly, no invitation shall be issued to the public to subscribe for any debentures or securities of the company. The number of members of the company, exclusive of persons who are in the employment of the company and persons who, having been formerly in the employment of the company, were members of the company while in that employment and have continued to be members of the after the employment ceased, shall be limited to 200. The company shall not accept or invite deposits from the public except from its members and directors or relatives. By virtue of that, my lord, statutorily it's a completely private company. It's a private company, and lordship may see page 78, the same articles of association. Funding source is there, page 78 at 43. Point number 43. Money or funds belonging to the company shall be paid primarily into the hands of the secretary chairman, who shall deposit the same into one account to be opened with any bank as approved by the board of directors in the name of the company. Funding is, my lord, gap funding. There are gap funding. Gap funding is there, and moreover, there are some CSR fundings are also there. Philanthropic organization, government is also funding it. Government is funding it, no doubt. Government is funding is there, my lord. Funding is there, but these government persons that they have highlighted in the audit report, they are nominated directors, and nominated directors have got fiduciary leadership.
Accepted, my lord. It's accepted, but in the same audit report, it has also been stated that it's a private company.
Public function.
There is no depend purposive conflict. Yes. Funding is there, but that doesn't mean that funding is entirely for entire percentage of funding is from government. Percentage, my lord, I have not gone into the details of that. Definitely, it's a facilitator of the government things. Definitely, facilitator. Some control is there, but the yes. Not like it's optional. It's a company limited by guarantee. There are no share capital, nothing like that. And whatever funding is there, it's a gap funding. Gap funding done by the government. Some portion is done by the self-generated, and some portion by other philanthropic organizations. It's like that. Some control is there, but the deep and purposive control is not explicit. Yes, my lord. Nominated director has fiduciary relationship as far as the role is concerned. Directors. Yes. To the director is there. And my lord, if we go to the memorandum of association, if we go to the memorandum of association of the company, which is as page 82, Annexure 3 of the affidavit in position, the main objectives of the company are there. The main objectives, may I read it, my lord? A, to secure the health, safety, and welfare of the people through access to preventive care and medical treatment of cancer by constructing and managing a cancer hospital, diagnostic centers, cancer hostels, cancer hospice, daycare centers, or other such infrastructure as deemed necessary, providing ambulance services and emergency call response centers for imparting critical care nursing for cancer and other patients, developing tie-ups with hospitals, infirmaries, clinics, dispensaries, diagnostic centers, laboratories, recovery centers, and research centers in order to administer medical advice and treatment of cancer and other critical diseases. Number 4, managing and establishing sanatoriums and or temporary residential accommodations and shelter for poor, needy, and deserving cancer patients and their relatives. Number 3, to impart education and training to oncologists, nurses, paramedicals, and other people associated with the field, directly or indirectly, either by itself or in association with other entities, in order to tackle the rising need of cancer care and other critical diseases. In point number 4, the last 4 lines, in respect of such innovations, invention, and technological advances, either in the name of the company or in the name of the innovator or inventor, as legally permissible and advised to utilize the same in the treatment of needy cancer patients. Page number 83, my lord. Point number 14. My lord, here I am coming because of
One, my lord. I want to cite one Supreme Court, Honorable Supreme Court judgment, 1991, 4 SCC 578. Chandra Mohan Khanna versus NCERT. 1991, 4 SCC 578. Chandra Mohan Khanna versus National Council of Education, Research and Training and other. Held on the first page, there are only general principles but not exhaustive case to determine whether a body is an instrumentality or agency of the government. Even in general principles, there is no cut and dried formula which would provide correct division of bodies into those which are instrumentalities or agencies of the government and those which are not. The powers, functions, and finances and control of the government are some of the indicating factors to answer the question whether a body is a state or not. Each case should be handled with care and caution. Whether financial assistance from the state is so much as to meet almost the entire expenditure of the institution, or the share capital of the corporation is completely held by the government, it would afford some indication of the body being impregnated with governmental character. It may be relevant factor if the institution or the corporation enjoys monopoly status, which is a state conferred or state protected. Existence of deep and pervasive state control may afford an indication. If the functions of the institutions are of public importance and related to government functions, it would also be a relevant factor. These are merely indicative indica and are by no means conclusive or clinching in any case. The combination of state aid coupled with an unusual degree of control over the management and policies of the body and rendering of an important public service being the obligatory functions of the state may largely point out that the body is state. If the government operates behind a corporate while carrying out governmental activity and governmental functions of vital public importance, there may be little difficulty in identifying the body as a state within the meaning of Article 12. Page number 79, 579, point B. The NCERT is a society registered under the Societies Registration Act. Its object is to assist and advise the Ministry of Education and Social Welfare in the implementation of the governmental policies and major programs in the field of education, particularly school education. The NCERT undertakes several kinds of programs and activities connected with the coordination of research extension services and training, dissemination of improved educational techniques, collaboration in the educational program. It also undertakes preparation and publication of books, materials, periodicals, and other literature. These activities are not wholly related to governmental functions. Similarly, my lord, here also in the memorandum of association, most of the activities, most of the objects may not be directly related to the governmental functions in the Assam Panchakar Foundation case. The object of NCERT testing is to assist and advise the Ministry of Education and Social Welfare in the implementation of the government. These activities are not wholly related to government functions. Thank you. Objectives in the memorandum of association here also, my lord, there are several ancillary objectives. So these ancillary objectives are not the objectives of the government. These are the objectives of the company. Now coming to the contract, of the petitioner, engagement contract. My lord, it's a not termination of contract. It's a non-renewal and non-extension of the contract. There is a difference between termination and non-renewal and non-extension. Only her contract is not renewed. It's not termination. So the
what termination should not be applied here. Termination is, as per page number 29 of their annexure A in the petition, termination of contract is point number 9.3. In case ACCF terminates this contract for any misconduct found on your part during the contractual period, the termination shall be with immediate effect and you shall not be entitled to any compensation. This is not termination of contract, my lord. In page 42 of annexure E, the letter says like this: Dear Dr. Sanghamitra, on 26 July 2024, we had a detailed discussion with you on renewal of your engagement contract with ACCF. This is based on the request put up by you for review of your professionality via email dated 18 July 2024. During the discussion, we had clearly mentioned that as per company policy, 6% increase on your current professional fee can only be considered, and you had agreed to it. But it has now been brought to our notice that you have requested for profit sharing for a few of the procedures. Since the practice of profit sharing is not available to the full-time consultants of ACCF, management has decided to exit the engagement contract with you and not renew the same. So, my lord, it has clearly stated that not renew the contract, exit the engagement contract and not renew the contract. Nowhere it has been stated that because of this we have terminated you by virtue of this. Again, my lord, lordship may kindly see page number 40, annexure D. There is an email communication dated August 23, 2024. That is after the discussions of July, online discussions of July. Here, Dr. Sanghamitra has written to some other doctors, that is, our senior doctors. Here, sir, it may be done for extra remuneration. My procedural charges are 6,000 INR per USD guided procedure, 8,000 INR per CT guided procedure, 8,000, 10,000 INR for PICC lines, and 25,000 INR for PTPT procedure. Also, it has come to my notice that you are asking visiting anesthesist to put PICC line in my behalf using radiographer and nursing from radiology, which I cannot allow. Moreover, the anesthetist concerned is not trained in doing so and is pestering our staff to teach and assist him, which is very laughable actually. In the given circumstances, it is only legitimate that an understanding is reached between me and the hospital for all the above mentioned procedures, and we get our due remuneration. It is in reply to a mail which has been written by her reporting head, Dr. Navajyoti Chaudhary, on August 23, that is on the same day, below, where he has stated that, Dear Dr. Sanghamitra Saha, it has come to my notice again and again that you have refused to see consult patients sending from outside. It was negligence of duty causing serious concern of patient care in DCC. You have also been informed that all patients referred from ACCF sister hospitals should be treated prioritized as per organizational decisions. Hereby, you are requested not to refuse any patients in future coming to your department, especially when it referred from any sister ACCF unit. It is for your information and strict compliance. My lord, these things are going on for a very long period, but because of the reputation of the institution and because of the reputation of a doctor, these things are not being mentioned in the termination, in the non-renewal of the contract letter. So the organization decided that for the sake of reputation, these things are not delved into and let the contract be not renewed. That is a very important point, because the reputation of a hospital, which is completely into the service mode, this is like an NGO, my lord. This is not for profit organization. These reputational things would hamper them in a long way. So this has not been mentioned. But see, after the issuance of her letter on 9th September, she herself has stated the decision to unanimously terminate my contract, citing reasons for profit sharing, which is always subject to negotiation discussions, is not valid at all. Here, I would like to add that I demanded for procedural cuts and profit sharing base. My lord, these are not terms of the contract. When contract is there just for a mutual agreement, when mutual agreement is there, not there, how can the contract be extended? It is for that simple reason the contract has been not extended. And the termination word has not been made there just because to save the reputation and for the career of the doctor, career of the petitioner. That is why the termination and other things are not done into, and they have not dealt into the other things which she have continued to do so. So, my lord, this is not an undue termination. This is not termination, this is just a non-renewal of the contract. Non-renewal of the contract can anyone can take. It's the terms and conditions of the contract, my lord. Then why the contract is there? Moreover, there is the arbitration clause is there, my lord. If she is actually, we have added some lines because in the actually in the online discussion, these things were told repeatedly to her, and she never accepted these things. And she later on, although she wrote that I have agreed to 6% increase, which is for all employees of the organization, and she is not even an employee; she is a consultant radiologist on a contract basis. These things are discussed in the online meeting, and on the last online meeting, that is of 9th of September, again she was told, we are not into profit sharing mode. This is not a profit sharing organization. So whatever you do, you have to do as per these terms. And this term is that 6% only increment will be provided to you. So she has set her terms, my lord. She has set her terms, and that terms were not accepted, and the contract has not been renewed. It's as simple as that. There is no arbitration, nothing, no malafide intention, nothing. On the contrary, she herself is putting her victim card. Nowhere it has been stated that we will deny the maternity benefit. She has to apply for that. There is a procedure. And that letter she has written after termination, where she has stated everything. And she was overburdened with work, accepted. When overburdened with work, generally an employee goes for additional support. She may seek some additional support. She may have to place some that I am overburdened with work. Can you please give me some assistance? But no, she always demanded the remuneration and other things, the monetary part of it. Which one? No, it was not a part of the contract. Contract was not. 6% enhancement is a general increment given to all the employees. It's not because of performance or anything, just because the consumer price index, this is increased. This is the consumer price index and market price. And lastly, my lord, regarding the maintainability of the case, my lord, there is one case, writ appeal number 5 of 2022, passed by this honorable court. Of 2022. Name of the parties is Amarjit Burman and 4 others versus the state of Assam and 4 others. The judgment was delivered on 17/10/2023 by Division Bench Judge. You may kindly see paragraph 26 at page number 16. A profitable reference may be made to the similar case of Barak Upataka DU Karmasari Sanstha Supra above, wherein the Honorable Apex Court has observed, which is reproduced herein under, the various averments of the respondent in the writ petition about the all-pervasive financial, administrative, and functional control of Kamul by the state government, even if assumed to be true, may be at best result in Kamul being treated as state within the meaning of that expression under Article 12 of the Constitution of India. If it is a state in case of violation of any of the fundamental rights of its employees by Kamul as employer, the employees were entitled to claim relief against Kamul by taking recourse to a writ petition under Article 226 of the Constitution of India. But the fact that a corporate body or a cooperative society answers the definition of state does not make it the state government, nor will the employees of such a body become holders of civil posts or employees of the state government. Therefore, the fact that the Kamul may answer the definition of state does not mean that the state government is liable to bear and pay the salaries of its employees. If the salaries are not paid, the remedy of the employees of Kamul is to proceed against Kamul in accordance with law by approaching the forum under the appropriate labor legislation or the Cooperative Societies Act. But a trade union representing the employees of a cooperative society cannot, by filing a writ petition, require the government to bear and pay the salaries of the employees of the cooperative society. Howsoever pervasive the control of the state government over such society, nor is any right created to demand the continuance of financial assistance to a cooperative society on the ground that such assistance has been extended by the government for several years. The respondent has not been able to show any right in the employees of Kamul against the state government or any obligation on the part of the state government with reference to the salaries emoluments of the employees of Kamul, either under any statute or contract or otherwise. And accordingly, last line, both the appeals are dismissed and it doesn't come under the part 2 of the Article 12 of the Constitution. The same thing happens here. Here she is an employee. It's a contract between her and the HR department. That contract has not been renewed. So it's a right between the HR department of that company and the petitioner. Had she been aggrieved, she could have gone for arbitration and other civil recourses are there. This is not, I don't think your lordship knows very well that this is not the proper forum for agitating such a right against a company. And violation of the contract is a private law, my lord, not a public.
Lord, 2-3 aspects. Let us first deal with that Article 12 point, my lord. My lord will kindly have this Biswas judgment, my lord. My lord, I may give you a little background of this aspect. Honorable Justice Bhagavati, my lord, in Dayaram Ramanna Setty's case, my lord, brought out this concept of, my lord, extended arm of the state. A time came, my lord, that government also started entering a commercial arena. The normal bureaucracy consisting of IS officers was not good enough to carry out those functions. It was then, my lord, it felt the necessity of corporations. Some may be societies. It's a juristic person. Let us not go by the form, my lord. It may be a corporation, it may be a company, it may be an entity by virtue of an act of the legislature, it could be a society to undertake those functions. Can we say, therefore, those activities which are being performed by these corporations or the entities are not governmental functions? Exactly. Therefore, my lord, these are nothing but extended arm of the government. Now, my lord, when it comes to healthcare, my lord, it is so kind of this Tata Group, my lord, that they join hands with government of Assam in extending treatment for cancer care. It's a very, adorable, gesture on the part of the Tata Group, my lord. But nonetheless, here is a case where Assam government's contribution is 1,080 crore and Tata Group's contribution is slightly less than 900. And my lord, that building is just behind my house residence, my lord. So can it be said that, yes, it's a company, but who are the person comprising the company? All are the board of directors. The board of directors is Chief Minister of Assam, Health Minister of Assam, then my lord, the Health Secretary of Assam, etc., etc., and 2-3 other directors from the Tata Group. And they are discharging a public function. What is the function, my lord? They are providing health care. And health care is one of the function, my lord, which is enlisted in the list 2 of the 7th schedule. Therefore, to say, my lord, that this concept, my learned friend has referred to Chandra Mohan Khanna's case, where NCRT was held to be North State. That was in 1991 4 SCC. Much water has flown, and precisely that is what has been discussed in Pradeep Kumar Biswas's case, my lord. Please come to this paragraph 87. Please come to page 151. Kindly see, my lord, these concepts have all, undergone a change. Page 151. Here itself, we have a few comments to offer. Firstly, the distinction between instrumentality and agency on one hand, and authority for the purpose of other authority on the other, was totally obliterated. In our opinion, it is one thing to say that if an entity veiled or disguised as a corporation or a society, or in any other form is found to be instrumentality or agency of the state, then in that case, it will be a state itself in a narrower sense, acting through instrumentality or agency, and therefore included in the state. What more is required, my lord? This company is nothing but discharging the governmental function of extending health care. And whatever may be the nature of that juristic person, that is immaterial. What is material is kindly similar. In our opinion, it is one thing to say that if an entity veiled or disguised as a corporation or a society, here it is company, or in any other form is found to be instrumentality or agency of the state, then in that case it will be a state. So they are in fact rendering a function which state is normally supposed to do. State government, because of its resource crunch, is not in a position to do everything of its own. Therefore, they have joined hands with somebody. The idea is to extend helping hand in the healthcare sector. So it constitutes a state, not even other authority. I'm reading it once again, my lord. In our opinion, it is one thing to say that if an entity veiled or disguised as corporation or a society in any other form is found to be an instrumentality or agency of the state, then in that case it will be a state itself in a narrower sense, through acting through the instrumental agency and therefore included in the state in the wider sense for the purpose of Article 12. Having found an entity, whether juristic or natural, to be instrumentality or agency of the state, it is not necessary to call it an authority. So in such a situation, we need not even bring in the analogy of Article 12. All that we can say it's a state for all practical purposes. It would make a substantial difference to find whether an entity is an instrumentality or agency or an authority. Anyway, secondly, Ajay Hasia, that is a test. Kindly come to the third one in Placitum G. Thirdly, those 6 tests are laid down, but there is no clear indication in the judgment whether in order to hold the legal entity, the state, all the tests must be answered positively, and it is the cumulative effect of such positive answer which will solve the riddle, or positive answer to 1 or 2 more tests would enough to find out the solution. It appears what the court wished was reaching a final decision on an overall view of the results of the test. Compare this with what was said by Bhagavati J in Ramanna. We have already noticed that in Ajay Hasia, Bhagavati J has in his own words summarized the test led by him in Ramanna. In Ramanna, he had said that question whether corporation is a governmental instrumentality or agency would depend upon variety of factors which defy exhaustive enumeration. And moreover, even amongst these factors described in Ramanna's case, the court will have to consider the cumulative effect of these various factors and arrive at its own decision. It's a fact, my lord. No exhaustive test can be laid down, but if the cumulative effect is to take over the function of the state, then it has to be construed as a state. It will not be an authority under Article 12. Now, if we go by the aims and objectives of the company, as has been delineated in the Memorandum of Association and Articles of Association, it is nothing but they have stepped into the shoes of the state, with the funding of the state, with the directors being the governmental nominees. So there is a deep and pervasive control. Therefore, we ought to say that this institute, this entity is not from performing a state's function. It would be, in my humble submission, a wrong description of the functioning. It is, in fact, substituting the role of the state. They have stepped into the shoes of the state in the form of a joint venture of state and this entity. Therefore, to take the color of state, my lord, would be a wrong decision. Secondly, my lord, my learned friend has made out a point that it is not a case of termination. It is a case of non-renewal of contract. I'm sorry, my lord, this can't be. Please come to that order once again. Before that, my lord, please come to the contract at page number 29. In what situation there could be a termination of contract? Page 29. (9.1) and 9.2. ACCF shall be entitled to terminate this contract at any time by giving 30 days notice or by paying 1 month's fee in lieu of the notice. You shall be entitled to seek termination of the contract at anyway, by 2 is by the petitioner and 1 is by the employer. Now, my lord, unless it is a termination, you are not supposed to give 30 days pay. If it's a case of non-renewal of a contract, where is the obligation on the part of the respondent number 3 to give 30 days notice? Now, please come to the impugn order at page 42. Yes. 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 No, my lord, please come to 42 once, my lord, just to take note of my learned friend's contention. The second para. You are eligible for 30 days notice as per clause 9.9.1. So you have terminated me. That's why you're paying this. Now, public order publicly made has to be construed in the context in which it is made. My learned friend's argument will not do. Public order publicly, it says that they have invoked 9.9.1. When can 9.9.1 can be invoked? When there is, it's a case of termination. So it's a pure and simple case of termination, that too based on some allegation. Therefore, my humble submission is the procedural safeguard, which is otherwise available to me, has been denied. That is why it's a case where judicial review is permissible. That is my. I'm deeply. Yeah. Deeply.
Matter relates to pension, or family pension of the person. In fact, Malat, earlier there was a private respondent. The service of notice upon them has already been completed.
I'm for a private respondent. Today we have filed a for respondent number 458. Time may be given for our.
Well, there is yes, Malat, obviously they are entitled to get some time. Malat, specifically that's a family pension matter. Malat, rule is very specific. Only wife is entitled to the pension at due. So specific date so that it can be. Or can it be earlier to that? It's because PLCs kindly look into the order sheet. The notice upon them has already been served way back in Malot. Malot. Malot.
Google. 4, 5, and 6.
I'm appearing for 1, 2, and 3, Lord. 1, 2, and 3.
So in this case, my lord, is agreement order by which he was not called for interview, my lord. On the ground that in his caste certificate, the name of the sub caste that was not mentioned. My lord, and the petitioner is a graduate, my lord, and he passed his graduation in the year 2019. My lord, and he belongs to the Chitilka community, and his sub caste is Mali. That is an extra three, my lord. Sub caste is Mali. My lord, an advertisement was issued. Your lordship will find the advertisement at page 16. It was issued by the Indian Oil Corporation Limited, and various posts were advertised. And the petitioner applied for the post of junior engineer assistant for production. Now, my lord, as per this advertisement, my lord, there will be two types of tests, my lord. One is computer-based test, that is the written test, and thereafter, if he pass the computer-based test, then he will be called for the skill, proficiency, and physical test. That is at page number 28, my lord, of the advertisement. Now, my lord, in the said advertisement, my lord, the petitioner was required to submit his caste certificate as per the format given in the website, my lord. So, my lord, as he passed his graduation in the year 2019, my lord, he already had a caste certificate obtained from the office of the deputy commissioner. And my lord, he appeared for the computer-based test, and in the computer-based test, my lord, he passed. The cutoff mark was 47, and he scored 51. Lordship will find that in page 47. Annexure 8, page 47. And in the remarks column, my lord, it is stated that caste not verified as name of caste not mentioned in the caste certificate. Now, I would like to draw your lordship attention to the caste certificate. That it's Annexure 6, page 41. Page 41 and 42 is the caste certificate. My lord, this caste certificate was issued to me by the office of the Deputy Commissioner, Kamrul Rural, in the year 2019. Although the advertising is 2024, but this caste certificate was issued in the year 2019. Now, my lord, the format of the caste certificate that which we have downloaded from the website as given in the advertisement is in Annexure 5, page 39. The same type of caste certificate which I have got. But, my lord, I was rejected on the ground that my subcaste is not mentioned. Subcaste is not mentioned. And on that ground, my lord, I was not called for the blood fiber. Caste certificate, your lordship will in the form, my lord, I obtained the caste certificate in the state caste certificate in the year 2019 after I completed my graduation. Oh, my lord, my lord, Annexure 8, page 47, my lord.
Page 41, man.
Annexure 8, page 47. No, I'm coming to that. Annexure 8, page 47 is the scorecard, my lord. It's the scorecard. In the remark column, it is mentioned that caste is not verified as name of the name of caste not mentioned in caste certificate. Annexure 6 is the caste certificate, my lord. That was obtained in the year 2019. 6 page 41. It is mentioned as scheduled caste, but subcaste is not mentioned. Subcaste not mentioned. But in the earlier, my lord, original caste certificate, that I have deputy commissioner, office of the deputy commissioner. I have to submit a state certificate at the time of applying for the state post. But this was issued by the office of the deputy commissioner. Yes, Annexure 3, my lord. Annexure 3, this is the original caste certificate. In this state caste certificate, my lord, the subcaste name of the subcaste is mentioned as Mali, man. Yes, my DC office. So DC office actually did not mention the word Mali, my lord. Subcaste Mali. But now, my lord, DC office has also clarified, my lord. We have submitted an additional affidavit. Additional affidavit, my page starts from 114, my lord. In the additional affidavit, I have got. Deputy Commissioner is also party in this case. My lord, may kindly see Annexure 11, page number 118 and 119, my lord. During the pendency of this case, my lord, Deputy Commissioner has issued this letter, my lord. Now, my lord,
Posts are kept vacant, man. But those two posts have not been filled up. I'll make my submission.
Yes, my lord, I want to moment. My lord, caste certificate, my lord, that was issued from the office of the Deputy Commissioner, my lord, and they failed to mention that subcaste is Mali, my lord. Now, in this regard, my lord, there is a similar type of case in where, my lord, regarding the it is regarding admission in a medical college, my lord. Here, my lord, the father of the candidate, my lord, he happens to be from the Indian Army, and some certain things were left out in the that certificate, and so my lord, this was allowed, my lord. But no, this is no, this is judgment, my lord. 2005 9 SCC 779, my lord. 2005 9 SCC 779. 2005 9 SCC 779. My lord, here it is. I'm just reading the head note, my lord. On fact, appellant undoubtedly belong to the reserved category concerned. there was only a shortcoming in submission of the proof of the same due to an error in the certificate concerned. Said error have been committed by the issuing authority. Said error have been committed by the issuing authority. In any case, the corrected certificate was produced by the appellant at the of second counseling. Therefore, in view taken by the authorities in denying admission to the appellant was wholly unjustified and illegal. The appellant have qualified in the JE 2003, but having been denied admission due to the fault of the authorities, who adopted a very high technical and rigid attitude, appellant to be given admission in MBBS in any of the state medical colleges in the current academic year. And apart from that, my lord, I would also like to draw your lordship attention to paragraph, my lord, 7, 9, and 10. The facts of the case is narrated in para number 3, my lord. And my lord, another thing I want to point out, my lord, in my affidavit in reply, my lord, at page number 65 to 105, my lord, I have submitted the office memorandum, my lord. And my lord, page number, my lord, 101. Uh, 101 of my lord, affidavit in reply, my lord. Provisional appointment in case of false certificate produced by candidate, where a candidate belonging to scheduled caste, scheduled tribe, and other backward classes is unable to produce a certificate from any of the prescribed authorities, he may be appointed provisionally on the basis of whatever prima facie proof. My lord, 101, page 101. This is a office memorandum, my lord. The office memorandum it starts from, my lord, page number 66. Page 101, number 4, my lord. Your lordship has got it. Page number 101 of my affidavit in reply. Page 101. This is an annexure, my lord, 9. Annexure 9. Page number, it will be 100. Annexure 9 starts from page 66, but relevant portion is 101. Where a candidate belonging to a scheduled caste, scheduled tribe, and other backward classes is unable to produce a certificate from any of the prescribed authorities, she may be appointed provisionally on basis of whatever prima facie proof she is able to produce in support of his or her claim to her furnishing the prescribed certificate within a reasonable time, and if there is genuine difficulty in his or obtaining a certificate, the appointing authorities should itself verify his or her claim to the district magistrate concerned. Now, my lord, in this case also, the authorities, my lord, the IOC, my lord, they may have called for certain report from the deputy commissioner, and on the basis of that, my lord, that letter was issued, my lord, which we have annexed as annexure 10, 11, and 12, my lord, in our additional affidavit. So, my lord, he belongs to subcaste Mali, my lord, and only we are seeking for that he should be called for the interview. Interview means skill, proficiency, and physical test, my lord. Only that much fair we have. We are not seeking appointment, my lord. No, he passed the written test, but he didn't come for the interview. He did not for the interview. Did not contain the word Mali. That is the thing.
Lordship kindly turns to page 41, ma'am. And now, if we take into consideration the certificate produced by him at this stage, my lord, it will amount to taking documents, my lord, after the due date. Lordship kindly peruses the first certificate. This is to certify that the so and so, son, daughter of so and so, village so and so, district so and so of the state, Assam, belongs to the scheduled caste. And if your Lordship peruses the same, the vis-a-vis page 112, the Lordship compares it with page 119, madam. 19. The language is the same. This is to certify that the so and so in the state of Assam belongs to the Mali caste, which is a recognized schedule. Therefore, my lord, there is no dispute of the fact that the certificate produced by him while submitting his documents for his, in support of his candidature, that is defective. No, my lord, he has obtained it in 2019, my lord. It was his burden. It was his burden to correct it, my lord. No, it is not my case. But no. But from this certificate, this is apparently defective, my lord. Maybe, my lord. But I'll rely on a judgment of the apex court, my lord, where the consequence, because now if we take into consideration, 2 vacancies are available, no difficulty in that. We have kept it vacant pursuant to the order. No, my lord, that will not be our burden, because as per the advertisement, he is to produce the certificate in the format prescribed. That is at page 34. Format is this is the format. 41 is the certificate produced by him, and page 39 is the format. But this is the same format. Although in the writ petition he pleads that he has downloaded the format and then obtained the certificate, that is not correct, because the advertisement is of 24 and the certificate is of 2019. Page 34. Hello. This is a junior engineering assistant grade 4 production. These are all ITI trainees, my lord. No, definitely not. Exactly. We have to, my lord. We have to, because now, yes, not only getting the best, my lord, best, but the documents has to be correct, my lord. Because if we have to now verify each and every document, my lord, it will be a Herculean task on our part. That is why the advertisement specifically provides that it is your burden to provide everything. May I just point out those clauses, my lord? I will not troubling your lordship by reading everything, my lord. Page 29, if your lordship turns, my lord. Yes. Yes. Because we cannot ascertain, my lord, whether this is correct or not. We cannot ascertain, because the subcaste has to be mentioned, because it says it is under the Constitutional Scheduled Caste Order 1950. What is the subcaste? I am not questioning, but the subcaste has to be mentioned. The certificate has. That is the subcaste, my lord. He belongs to the so and so caste, which is a recognized scheduled caste. It cannot be that he belongs to the scheduled caste and it is a recognized scheduled caste. Exactly. But now, no, our ground of rejection is that subcaste is not mentioned. It is reflected, man. It is reflected. This is the format. No, he has used this because he has obtained this in 2019. So he has applied before. Maybe, man. Maybe. I'm not saying it is not genuine. I'm saying it is defective, madam. No, it does, my lord. It does. Lordship will again come to that point, my lord. This is to certify that so and so belongs to the so and so caste. He has to mention the caste. That caste is a recognized scheduled caste. Under what? Under the Constitutional Scheduled Caste Order 1950. Because we have to verify, my lord. Exactly. But we have to verify because this is an all India recruitment, my lord. No, but we have to verify. No, we have to verify. But we have to verify whether this is correct or not. No, we are not accepting that. It is issued by the Deputy Commissioner, but it does not say which subcaste it belongs to. No, I am not questioning the genuineness. But the question is that it is a defective certificate. It is a defective certificate. That is my submission. Because it does not mention the subcaste. It does not. For that, my lord, I'll rely upon a judgment, my lord. 2025 SCC Online Supreme Court 1125. Because now the question of considering the subsequent documents will also not come, my lord. We have to decide on this. No. No, I'm not saying that. I'm not saying. I'm not saying. No, it matters to us because, my lord, we cannot ascertain whether he is genuinely scheduled caste or not. From a bare reading of the certificate, my lord. Because we refer to the scheduled caste order, my lord, of 1950. There Mali is specifically mentioned. No, ground of rejection does not say so. I cannot go beyond the ground cited, my lord. Exactly. So kindly bear with me, my lord. The ground of rejection is at page 47, 47. Caste not verified as name of caste not mentioned in the caste certificate. So now I cannot say that I am doubting the genuineness. I'm not doubting the genuineness, but we cannot verify. Exactly. But can we give appointment on the basis of a defective certificate? That is the only. I'm saying it, madam. The caste is not mentioned. That is why. Page 47. Caste not verified as name of caste not mentioned in the caste certificate. Because we have to. We have to verify, madam. No, why this is done? Because this is an all India recruitment, madam. Someone who is a scheduled. No, someone who is a scheduled caste in Bihar may not be scheduled caste in Assam, madam. No, forensic. The question of forensic has not come because the nexus is that we want a genuine candidate, my lord, who belongs to the scheduled caste. But without mentioning, how do we verify, my lord? It is issued, but the caste is not mentioned. No, genuine means, my lord, it will be amount to, we are not alleging fraud against him. But the caste certificate is defective. That is what I am saying. Lordship. I leave that to your lordship, my lord. My submission is that we had to verify it is not mentioned. Lordship. My lord, here the facts were slightly different, my lord. Here the question, it was a question of whether they belong to the creamy layer or not of the OBC, my lord. Now, para 14, my lord. No, para 14, my lord. Para 14. What follows from the above decision is that irrespective of whether an aspirant for public employment belongs to a particular community, like SC, ST, OBC, the status claimed by him for being accorded the benefit of reservation is per se not decisive. Such status has to be certified by the competent authority upon following due process and identification that the aspirant is what he claims to be. In so-and-so versus so-and-so, the requirement of production of a certificate from the competent authority was held to be mandatory in view of the statutory mandate. Although there is no such statutory mandate in the facts of the present case, the requirement in question is no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardsticks for different sets of aspirants. Non-compliance with the terms of the advertisement notification is bound to trigger adverse consequences of rejection of the aspirant's claimed status by the selecting body appointing authority, should he choose not to adhere to the same. Having regard to the selecting body would be justified in not entertaining the application of an aspirant as a member of the community from whom reservations are permissible. The proposition of law as settled by the above decision does not appear to have been doubted in any subsequent decision, and we do hereby endorse the same. Let us now examine whether in the light of the settled law in this behalf, Mohit and so-and-so deserve any relief. Clause so-and-so of the recruitment notification has been noticed above. It clearly warns that the consequences would be, should an aspirant fail to submit the requisite certificate in format 1, admittedly, the certificates submitted by so-and-so and so-and-so do not align with format 1. Viewed thus, we need not even carry the discussion forward to ascertain whether Mohit and Kiran have been unfairly treated. However, since it has been assiduously argued by so-and-so that so-and-so after all belongs to the OBC category, and Mr. so appearing for Kiran has supported him, we consider it proper to deal with such argument too. Here, the government of UP is the appointing authority. The appointments would follow once so-and-so makes the necessary recommendation. We may skip this, my lord. 19. It is no longer res integra that terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution, or for that matter, Article 14. Once an advertisement is issued inviting applications for public employment, it is the responsibility, nay, duty of the aspirant to read and note the terms and understand what its requirements are. If any aspirant finds any of the terms ambiguous and there is scope for an inquiry inbuilt in the advertisement or is provided by any rule regulation, an effort ought to be first made to obtain clarity for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a representation. Should such clarity be not provided, the aspirant may participate in the process without prejudice to his rights and may question the term even after he is selected, even if he is not selected. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term in the advertisement and later he emerges unsuccessful, ordinarily, it would not be open to him to challenge the selection on the ground that the disputed term is capable of being understood differently. In such cases, the court should be loath to entertain such plea of ambiguity while preferring to accept the recruiting authority's understanding of the said term. This is for the simple reason that the recruiting authority is the best judge of what its requirements are, and it is such understanding of the recruiting authority that would, we may skip this, Malad. So, reading of this judgment, Malad, it says that the certificate is necessary to certify that he belongs to that category. Here, it is defective. That is my respectful comment. And now, at this stage, we cannot take into consideration the subsequent documents which he has brought in by way of an additional evidence. (47) Process for verification. We see this upcast with the 1950 order. We verify that if it is in order. But if we genuinely doubt, then we may ask for a clarification from the DC. Because the burden is also on him, my lord. I'm with her lordship. Lordship is saying that not a technician, my lord. Not a technician, is a junior engineer. ITI. Okay. Because now if we compare the format with page 119, my lord, the language is exactly the same. I draw your lordship's attention to 119 again, my lord. No, my lord, it is of 2023, prior to the advertisement. 119. 119 and 41, if we read together. I am reading 41, my lord. Lordship will kindly take up 119. This is to certify that Sri Kanganjyoti Malakar, son of Dharmeshwar Malakar of village Borchapri in district Kamrup. The details of the address is not there in page 41. Of state Assam, belongs to the, here it says Mali caste, here it says scheduled caste, which is a recognized as scheduled caste under the constitutional scheduled caste so and so. This is issued by the same authority, I think. Government official, same authority. And moreover, my lord, this, even the annexure 3 to the writ petition, that also contains the name, my lord. Annexure 3 is dated 2011. There also it is specifically states belongs to the scheduled caste subcaste Mali. Questioning the genuineness is something different, my lord. Here we are saying it is defective. We could not verify. And the advertisement starts at page 16, my lord. Lordship gives me just 2 minutes, my lord. I'll just point out the relevant clauses. Qualification required, lordship may not go because it is not in dispute that he has the qualification. Page 25, lordship may make a mark. Reservation. There also nothing much, my lord. Then page 28, the cutoff date is 31/7/2024. That may have some relevance, my lord. Page 28, clause I, towards the bottom. The cutoff date for the purpose of meeting age criteria and for possession of prescribed qualification. This is, of course, for the age criteria 31/7. Then the selection methodology, there is also no dispute on that. Then 8, my lord, page 29, last clause. It is his burden to upload all certificates. Then how to apply at page 32, clause Q. Yes, it is to be given in the format, page 34, clause 13, Roman 5. Lordship has got it. Page 34, clause 13, Roman 5. That it has to be given in the format. And also at page 33, last clause, my lord. Second last clause, clause 9. 9 at page 34. Page 34, 13, Roman 5. 1, 3, Roman small 5. SC disability so-and-so certificate along with declaration must be. Lordship is looking at 33 or 34. 34, 13, Roman 5 in the middle. And page 33, clause 9 towards the bottom. The candidates must ascertain the correctness of each information detail before filling the online application form and its final submission. The candidate shall be wholly exclusively responsible for the information details so filled. Yes. The general instructions at page 31. Not only that. The process is like this, while giving the written test, we do not verify the documents. Those who qualify prima facie, thereafter the process of verification takes place. That is clause J at page 28 and 29. Then Lordship may also look at page 32, 31 and 32, the general instructions. The candidature of the applicant. Yes. Selection methodology written and thereafter the verification. Clause 7, my lord, at page 29. Admit cards for computer-based test will be issued to all prima facie eligible candidates on the basis of the details furnished in online application so and so, so and so. Then last sentence, my lord. And only those candidates will be considered called for the next stage of so and so test who are shortlisted on the basis of CBT and meet the notified eligibility criteria upon verification of documents uploaded by the candidates and other parameters. So after the CBT, the documents will be verified. My lord. My lord. No, there is no separate procedure. Only that page 34 says that you have to submit it in the requisite format. No. The qualification, etc., what they are, the relaxation, etc., for SC/ST is at page 26, my lord, the concessions available. But not that how separately they will be assessed. I think there is an order of this honorable court, my lord, to keep one post vacant, and I think we have not filled up the other post as well. That is why the urgency was expressed by me, my lord, on the earlier occasion. Yes, my lord, there is an order of stay, my lord, 8/1 to 2025. It was directed not to fill up one post, my lord, but my instruction is that both the posts have not been filled up.
My lord, I want to point out one thing. My lord, so I like to draw your attention to page number 15. My lord, here it is mentioned as subcaste Malik. That's what I am mentioning. Subcaste Malik. Subcaste is Malik. Now in Annexure 5, page 39, belongs to caste. It does not mention subcaste or subtribe. So their format is also defective, my lord. The format which they have given, my lord. 119, my lord, that is different thing, my lord. That certificate is there. But my lord, this as per this format, my lord, if your lordship sees the Annexure 6 is the my caste certificate given issued by DG. Here, my lord, lordship may see the subcaste is not mentioned. The word sub is not mentioned, my lord. Mali subcaste. Mali subcaste. How will they know, my lord, that here this place is reserved for mentioning subcaste, my lord. They have mentioned caste only, not subcaste. In Annexure 3, it is clearly mentioned, my lord, subcaste Mali. But in the format, only caste is mentioned, tribe is mentioned, my lord. Not sub-tribe or subcaste, my lord. No, my lord. It is not in matter of inquiry. This format, my lord, is given in the website, and I have that format, and as per that, the deputy commissioner has issued me the certificate, my lord.
Day after tomorrow.
Abdul.
Like, can I give a copy of a judgment of the Jharkhand High Court now? A similar issue had come up. Then I'll not get. Then I'll not get. There also similar question had come up, Malad, whether a defective certificate can be considered. Yes.
Abdul.
Lordship, it's a parted matter, Lordship. Maybe fix any other day, Lordship. Lordship, Lordship, day after tomorrow, Lordship, if possible. Lordship, next Tuesday, if possible, Lordship. 17, 19, 17 June, 19th. Deeply open.
Where was it here? Morning he was on lake. Were informed. Both 4 and 5 he appeared. Even I don't know. Play.
I only want my lord, item number 24. 8 may be given on 9. From 24. 18, 19. My lord, there is an order to clear in the month of December, my lord. But not 24, my lord.
So DP matter.
DP. I have been removed, my lord.
Challenge of dismissal order.
I have been removed. That's fine.
Dismissal of farm.
Yes,
Dismissal from service.
Let me, I think I am for the petitioner. On a matter relating to removal from service, your lordship. We are challenging on 2 or 3. No interim because I have been already removed. I filed my lord appeal. August. Date, my
Item 19 year lordship. This is also a case of removal from service. On the other occasion, your lordship have given to bring them a record, and they have brought the record. They have brought the record. Okay.
थोड़ा December to make it.
Next week. Well, day after tomorrow, but I will not be available. No, well, ritual for function. Tomorrow I will come. Thursday and Friday I will not come. No, not put for me, my not put 17.
Not I.
Obliged. Keep your.
Let item number 28. Let this is dismissal from service. Your lordship has already had the matter. Only one document your lordship wanted to see. Your lordship may aware about the matter that without departmental proceeding, lordship, I have been removed from that. Any date in the
Record lordship is not available, but we have filed our affidavit.
My lord, under similar circumstances, another person was removed from service, and he approached before this honorable court, and this honorable court has set aside the order, remanded the matter back, and relying that order, lordship, my removal order was passed. Your lordship wanted to see
Lordship,
the
the
order
petitioner-
passed in that case. My lord, I am praying in this month, lordship, any day. Your lord. My lord, relying the my lord, that was without departmental
No, lordship,
initiating
he has
departmental
been
proceeding.
he has been dismissed from service by observing the provisions of Article 311(2)(b) of the Constitution
Yes.
of India and 10(2) of this service
Without
Assam Service
initiating
and Disciplinary
departmental.
Rules. Yes,
No.
lordship.
Your lordship already heard that there, if the inquiry is impracticable, in that event they can do it. They can exercise the power. But then
Regarding item number 27,
in 22 July, lordship.
Regarding item 27, we are praying for date. Any date, my lord. We are may I pray for one date. My obliged.
Lordship, item 21 and 22 after 2 weeks. It is in hearing, Your Honor. 5th of August. Lordship, kindly fix in July. First week of July. No need to fix the date, Lordship. Just after 2 weeks. Yes. We'll make.